All right, so let's a couple announcements. So everyone, if you will just look up at the monitors. What I'm going to do is go to your rights with you, and then get you or your attorneys to tell me what you want to do with your cases. So let's start out because there's multiple floors of court going. This is the Spalding County State Court. I'm Josh Thacker, I'm your judge, and this is the bonded trials calendar call. I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and dignity that you would wish for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, please don't talk during court. So our goal is to move your case forward efficiently, get you back to your lives, and I cannot do that if you are having sidebar conversations, and frankly, I won't have any patience for it. All right, we do have a couple of virtual people. One of them is an attorney. Go ahead right now and get a pen and a piece of paper or some way to capture information that I'm going to give you about your case. Please don't wait until I give you the information and then ask me to wait for you to go get a pen and a piece of paper. That drives me crazy. Wait for me to talk to you, and while you're waiting, please turn off your camera. All right, cell phones. So everybody has pet peeves. So my mom's is slow people in the left lane. Here's mine. You ready? Cell phones ringing in the courtroom. So here's the deal. Take out your phones right now from wherever you stashed them. Push that power button for 2.5 seconds and shut it off. Go ahead and do that now so that you don't step into my pet peeve. Because what's going to happen is somebody's phone is going to ring. It happens every day. And what happens is it means you've totally ignored my instructions, and we're going to have a contempt hearing. Please don't volunteer for that contempt hearing. It's the most preventable one I can possibly imagine. Okay, lots of movement out there. Thank you all very much. Again, that also lets us move faster, gets you all back to your lives. It's a win-win for all of us. All right, so this is really important. This is the correct courtroom for you if you were arrested on a misdemeanor here in Spalding County, you waived or appeared at your arraignment date and requested a trial. If what I'm saying does not sound correct, step out into the hallway, show the bailiffs your paperwork, and we'll get you to the right courtroom. Inevitably, some folks will be wandering down from upstairs where they went to the wrong courtroom themselves. All right, today is what's called your calendar call. I'm going to go over your rights with you, and then and then you or your attorney is going to tell me what to do with your case. Now, you may have a trial. There are two types of trials. There's a jury trial where 6 jurors sit in that box over there to your left to decide guilt or innocence on your case. And then there's a bench trial. That's where I issue the verdict with no jury present. You may have a conference with the solicitor's office if you're representing yourself. Your attorneys will certainly do so on your behalf. And then if you don't have an attorney, you can ask me about an attorney. Now, Ms. Karen is here from our Veterans and Mental Health Court. You also hear us call it our Accountability Court. So if you are a member of our military or you're a military veteran and you have a mental health diagnosis and you wish for your case to be dismissed, then if you're representing yourself, speak with Ms. Karen here at the first break and see if you're a candidate. If you miss a chance to speak with her and you're representing yourself, ask for a conference. The solicitor's office can explain the program and help see if you are a candidate. If you're represented by an attorney, simply speak with your attorney. They're very familiar with their program and they can answer any questions you may have about it. All right, everyone's charges in this courtroom are misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or a $1,000 fine. Now, a few minor traffic charges like seatbelt have a lower maximum fine, and a few high and aggravated misdemeanors have up to a $5,000 maximum fine. Now, each of you here have the right to a speedy and public jury trial. You have the right to have 6 citizens of Spalding County decide guilt or innocence on each of your charges. Again, you can also choose a bench trial. That's where you give me permission to make the guilt or innocence decision without a jury present. You can waive your right to a trial altogether and close your case with a plea if you so choose. I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. Now, each of you here have the right to be presumed innocent, to force the state to prove your guilt beyond a reasonable doubt, to cross-examine the state's witnesses, to subpoena your own witnesses and evidence to court. You have the right to testify or not testify. You have the right not to incriminate yourself. And if you choose to remain silent, your silence cannot be held against you. You have the right to an attorney. You may hire your own attorney, and there's certainly private attorneys here you can speak with. However, if you cannot afford an attorney, then you should have applied in the courtroom on your arraignment date, like I asked you to, with the Public Defender's Office, or taken prompt action after that. I warned you that if you did not take action ASAP to secure the public defender's office, you would very likely waive the right to have their services. All right, an attorney would help you understand our criminal justice system, would explain what your charges are and what the defenses are to those charges, file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf and make objections, protect your record and appeal a conviction, and otherwise work to protect you. All right, first offender and conditional discharge. It's my job to explain these to you all, and here's how they work. First offender and conditional discharge each allow you to enter a guilty plea without being convicted. However, you only get one of each, so for your entire life. First offenders for everything but traffic-related charges, so no DUIs, and conditional discharges for drug-related offenses only. All right, nolo contendere and traffic charges. So a nolo plea, that's what we call it for short, is where you enter a guilty plea without admitting guilt. Again, it is available on most traffic charges, no DUIs. You get one nolo every 5 years. It's measured from incident date to incident date, ticket date to ticket date. A nolo will usually prevent points. It'll usually save your license. It won't help you much if you're under 21. All right, if you're here today and you're not a U.S. citizen, it's my job to make certain you understand that any conviction will very likely have a negative impact on your immigration status. All right, family violence charges. Several of you in this courtroom are charged with family violence charges. You need to know that if you are convicted of those charges, then you will lose any Georgia weapons carry permit you have, and federal law will step in and say that you may never again possess a firearm or ammunition. All right, habeas corpus. It's my job to explain this weird old law called habeas corpus. We call it habeas for short. It does all kinds of things in all kinds of situations. But for our purposes here today, here's how it works. If you're convicted of these charges, you may sue Spalding County civilly over in Superior Court to challenge your conviction. All traffic charges have a 6-month window to use those rights before they expire. Everything else on the calendar has 12 months in this courtroom to use before your habeas rights expire. All right, you may conference today with the solicitor's office. If you're representing yourself, then when your name is called, you'll announce a conference. You'll remain here in the courtroom at your place until you're called. The solicitor's office, that's this group over here to your left, they represent the state of Georgia. They're not your attorney. If you reach an agreement with them, you can resolve your case today. If you do not reach an agreement with them, then you must return to this courtroom for me to personally give you your next set of instructions. And that includes signing the verdict form. And private attorneys, just a reminder again, I don't need to meet with they all. If they all get a verdict form signed into the solicitor's office, you're all clear. All right. If you receive probation today, you need to know that you'll be supervised by the Spalding County Sentence Enforcement. There'll be a one-time $25 intake fee, and 100% of all fine amounts can be worked off with community service work at a rate of $10 per hour. Additionally, there's a $50 per month supervision fee each month until you complete your probation. Now, this supervision fee is mandatory, but it can be waived after a separate hearing before me. All right, so everybody needs to know that this is a 2-week trial calendar. This is your calendar call here in week 1, and then we're going to skip a week in the middle while everybody prepares for trial. And then in week 2, the jury trials and bench trials will begin promptly at Monday at 9 a.m. sharp on week 2. Now, you will appear each and every day as directed until your case is resolved. We will use 2 or 3 courtrooms in week 2, and we will reach your case for trial. All right, you want to help your friends and family because bench warrants are going to be issued for the defendants who failed to appear. If you know somebody who's absent, because we're still a small enough community where everybody knows somebody who knows everybody, call them and tell them to get down here ASAP. You will save them a great deal of future trouble. All right, attorneys and intrepid defendants, you must let me know if there are any outstanding pretrial motions, speedy trial demands, or anything else that I need to factor into the hearing, the calling of your case for trial. Failure to give this information to me will result in waiver. Bench warrants result in waiver. All pretrial matters must be heard on the first calendar or they are waived unless I specifically preserve them on the record in open court. All right, I went with a lot of titles for this slide, but I just went with this is important because it tells everybody that this slide is important. So if you tell me you want a jury trial or bench trial, this is what you're telling me. You don't want a conference. You don't want an attorney. You don't want a continuance. You don't want to enter a negotiated plea. You don't have any motions, and you're ready for trial because this is your last chance to ask for these options. I have no intentions of exploring any of those options when I've got a jury outside that door ready to start your jury trial. All right, calendar call. I'm about to call the calendar. When I hear your name called, if you are able, stand up. If not, just make certain that I can see you and I know who I'm talking to. If you have an attorney, once you stood up or got my attention, remain silent. Let your attorney announce for you. So let me say that again, because I don't know how to. That's an issue every time. If you have an attorney, let your attorney announce for you. All right. If you do not have an attorney, then you're going to tell me what you want to do by doing the following. You'll get my attention. You'll announce jury trial, or bench trial, or conference, or attorney, and do you have any motions? All right, everybody, anything else before I jump in?
No, sir.
All right, let's jump in.
You ready for the one?
Yes, who's the judge?
Okay, page 1, at the bottom, Shannon Nicole Conrad. She, bottom of page 1, top of page 2.
Got it,
Page 2, Spencer Driver.
got it,
DeMonte Howard Duffy.
okay,
Page 3, Sean Giles.
all right,
Page 4, Anthony Jones.
okay. Everybody get all this? All right, and good job to Erica, she had those marked, so, I don't know what you did, but you nailed it. Okay, well, just saying, good job. So,
I sent it to her.
y'all don't know this, but I'm the luckiest judge of the state of Georgia. They make me look way better than I deserve. Okay, here we go. All right, Antonio Andrews.
Good morning, Your Honor. I was here for a jury trial.
Okay,
Jury selection.
so do you want me just to put you down for a jury trial and that's it?
Yes, sir.
All right, we'll have a conversation. Sit tight. All right, Yoshida Barkley with Ms. Miller.
Ms. Miller has a
I was
conflict.
about to say, she had some sort of conflict. Do you know when she's gonna be here?
No, but she's in McDonough, in state court.
Okay, if you will step out and check in with her office.
I did, they just told me to say that when you call my name.
Did they give you any sort of estimated time? Like, is she planning on making it today or is she tied up until tomorrow?
I think she's planning on making it today.
Okay, well then, if you wanna sit tight, that's fine. If you wanna step out in the office and check in with them and give us a more specific time.
Okay.
We anticipate this calendar should finish up somewhere around lunchtime, so if she's planning on coming this afternoon, it won't do her much good. So, okay, Ansley Bates,
Here, Your Honor.
all right. What do you wanna do?
Conference, please.
All right, conference it is, thank you. All right, Mr. Butler is here. Mr. Kendall asked if he could report at 10:15. I told him that would be okay. So, he said he wants a conference, so. Mr. Butler, you here? Tell me Mr. Butler was in the courtroom.
He left.
That's fine, okay. Alvin Capps?
Yes, sir.
Conflict, Your Honor.
Okay, we're good, thank you, Mr. Capps.
Judge, Mr. Capps has a second case.
Oh, this is, I think I just talked to your dad. This is Capps, okay.
Yes, this one's 23 SR 0970. That's an obstruction.
Are y'all familiar with that case?
Yes.
sir.
Yes, I am.
All right, because what I'm thinking of doing, since I've got 10 days, is adding that here, just so that they move
We're
together.
gonna try to resolve.
Yes, well, that's what I'm saying, but I wanted to officially move together. And are you a junior, senior, third?
I'm a third.
Third, okay. I'm gonna change that so that it's matching. All right, so he's the third. All right, then, so Conrad is y'all's and it's jail. We'll see her Wednesday afternoon. Ralph Culberson. Good morning.
Attorney.
All right, thank you very much. Sit tight. We'll talk in a minute. Octavius Dewberry.
Conflicts.
All right. All right, Spencer Driver's in jail. He's not yours, but I did show. Okay, so we'll see him Wednesday. DeMonte Duffy is yours. See him Wednesday. Finister. Good morning. Conference. Will you tell me how to pronounce your first name? Tajala. All right, thank you very much. Thank you. Belinda Finley, 2 cases. Good morning. Conference, thank you. All right, Christopher Galindez,
Yes, that was a plea of absentia,
Okay.
a while back.
Okay, so it's done?
As far as I'm aware.
Okay, we'll check and see. Giles is in jail, is y'all's?
Yes,
See you Wednesday. Okay, is it close? You just want me to come back to him? It's not.
Windows
The
is not?
plea is in here. I'll see if they can do it.
Okay, she says she thinks it's okay, it's just, we haven't closed the loop in the database.
I remember signing off on it, I just don't know what happened with it after that.
All right. Melvin Hare,
Conference.
all right, thank you. All right, Brandon Hightower. Corey Martin. Brandon Hightower, Corey Martin. Hold on, let me see if I've got
It's not Mr. Martin's case, Judge, I believe it's,
I've got somebody virtual, hold on, I've got an attorney virtual. No, it's Sonata.
It's supposed to be out, because that's an issue of,
Yeah.
I think, Kobe Martin,
Well,
but he's not present anyway.
okay,
I know we had sent, there's an entry from Mr. Martin, we had sent discovery. I don't recall having ever spoken with Mr. Martin about this case. And I know that Mr. Charles' office has filed an entry on it also, so
why don't we just bookmark it?
he's not here.
Yeah,
So we'll ask for a bond forfeiture.
that's very easy to sort out later. So, okay, I'm gonna issue the warrant, we'll sort it out later. And I'll put Martin as a no-show. Okay. All right, back to you, Mr. Charles. Kayla Hollis,
Conference,
all right. All right, Mr. Singleton, Tyson Holmes,
Give me a comment, yes.
okay. All right, Juan Jimenez, almost. Maybe that's on tomorrow's interpreter calendar. I'm opening Odyssey now. I'm just looking at the speeding charge.
I'm not sure. I sat down for
Okay, so it's not on tomorrow's calendar, and,
Really?
have you had any contact with Mr. Ballard on it?
Judge, I think so, but it's been quite a while. I just remember some emails going back and forth about discovery,
Okay,
but it has been a little bit,
Yeah.
but not recently, no, sir.
let's just bookmark it.
We'll ask for a bond forfeiture benchmark.
All right, granted. All right, Anthony Jones is, in jail, we'll see him Wednesday. Victoria Jones. Victoria Jones.
Ask for a bond forfeiture and benchmark.
Well, let me make sure that's, oh, that's why this sounds familiar. Victoria Jones is virtual.
Hi, Judge. I'm here.
Yes, no, you're here, I knew that, that was on me. There's no warrant. What do you want to do with your case?
I mean,
Actually, let's start here. May I have a phone number? Give us a phone number in case we need to reach you.
it's 678-386-1415.
All right, you gave me 678-386-1415. Is that correct?
Yes, sir.
All right, what would you like to do with your case?
Well, last time I did conference and I was told that there wasn't anyone to speak with me, so
Yes.
we rescheduled. So is the conference where I'm not even exactly sure what that is. Sorry, I'm in court.
The conference would be where you speak with the solicitor to see about resolving your case. And yes, I did not have anyone available last time, but I do today. So if you'd like to have your conference today, you certainly can.
Yes, I would like that.
All right, so here's what we're gonna do. I've put you down that we're gonna reach out to you at 678-386-1415. I'm gonna let you remove yourself from the video conference system, and you're gonna just wait where you're at for your phone to ring. And it's gonna ring probably about an hour or so, and they're going to have their conference with you. At the end of the conference, they will give you your next set of instructions.
Okay, so the conference call will be just phone, not video?
That is correct. They're gonna call, the
Okay.
solicitor's office is gonna call you at the number you just gave me.
Okay, I will look out for that phone call. Thank you so much.
All right, so 45 minutes or an hour, somewhere in that ballpark, okay?
Okay,
All right, do you have any other questions for me?
no, have a good day. I'll disconnect now. Thank you.
All right, thank you.
Bye-bye.
Dylan Carr,
Conference.
all right, thank you. Back to you, Mr. Charles. Marquita Kernan? Kernan? No?
That's for a bond forfeiture and bench warrant.
Kernan. You have any facts on that?
Yes, sir.
Kendrickus Matthews?
Conference.
Conference, thank you. Octavius Mays? Mays?
That's for a bond forfeiture and bench warrant.
Granted. All right, back to you, Mr. Charles. Janae Nix?
No, she called the office, she said her car broke down.
Okay.
And she's waiting for somebody to come and pick her up and bring her to court.
Okay,
So
Well,
when
It's
she
a
gets
second
here,
bench warrant.
okay. So, okay, well, we'll sort it out as soon as she gets here. So I'm gonna issue the warrant. Y'all let me know when she gets here and we'll sort it out.
thank you, sir.
I'm not saying lift it, but I'll at least give that extra consideration.
It's an old case.
Yeah. All right, Caitlin Parker, Mr. Dutton. I think, I was looking for Mr. Dutton this morning, but I haven't checked my conflicts, so just grab a seat. If you wanna step out in the hallway and call his office.
He's on the third floor.
He's on the third floor. Never mind, just grab a seat. I'm gonna put him down for a conference.
Yeah, he had another
Yeah.
client who's gonna bring it to 22.
Who's his other,
I'm right here,
what's your name?
Amber Lee Levine.
Okay, she's here because y'all told him that, okay.
Yes, sir. I think she's on Wednesday, maybe.
Carl, could you go up there and remind him he's got two down here?
Okay. Anybody else here, Dutton? I knew he would have two here today. Okay, that works. All right, back to you, Mr. Charles. Gianna Pompey,
Conference, Your Honor.
Brandon Pruitt. Oh, you're good, thank you.
Yeah, that's in my case, we'll do a conference on that.
Okay. Singleton. All right, Frank Ramos.
Conference,
All right. Tiara Reed, looks like 3 cases. 4, 5, 6, goodness. Okay,
Oh, that's right. So Judge, Ms. Reed, to begin with, will ask for a bond forfeiture and bench warrant in all these cases.
granted.
Secondly, she has a pending, we filed a motion to revoke her bond based on all these cases and the new case that she has pending. That's on for a hearing on Thursday morning.
Was on for here.
Was on for hearing on Thursday morning. Is that, will you let, no, Webb's already come in for that. Okay, so, well, yeah, he's still on it. And the third thing, well, let's see, there's also a pending bond revocation in Superior Court for Ms. Reed. And she also has an outstanding warrant for a stalking and unlawful use of a 911 call.
Okay. All right, well, it sounds to me that, okay, so I'm gonna go ahead and say this. If she shows up today, then we can address these. If not, I'll just recall it Thursday, but the warrants will stand. But obviously, if she comes in today, she'll have to go to jail because of the stalking. So, Mr. Charles, if there's a procedural step here I'm missing, I'm open for this discussion. I'm just trying to put all those pieces in my head as to what options I have since there's,
I have 6 cases, I understand there's a 7th one, which is the stalking.
Which she has not been arrested on yet, so we don't have the case.
Oh, so she has an open warrant?
yes,
Okay.
okay.
That's from August 30th. That is, she went to PDC back in May for like a 90 to 120. And it
Yes,
looks like about the same time she got out, she started stalking her victim again.
okay. Well, we'll cross that bridge when we get to it. For now, the warrants stand. And that means that we're welcome to still have the hearing on Thursday if you want, but it seems
I don't think
convenient
that,
to me.
yeah,
So,
I just had to do it.
That's a more issue.
yes,
It
that's
is
what I'm
now.
saying. You can call off your witnesses,
Right.
unless somebody desperately wants me to hear that. So,
And when, do you know when he's even upstairs on the bench?
I don't. I spoke with the DA's office last week, they checked the file, but
if y'all will come ask me after counter call, I'll look it up for you, or if Eric, if you don't mind looking it up, when is Tiara Reed's Superior Court bond revocation?
she has a trial scheduled in another case upstairs, an ag assault case upstairs for the first week of November. I do know that.
You know, some people just need to be in jail.
That's why we have jails.
Okay. So, okay, well, we'll sort that out when we find her. So, okay, David Robinson. Conference, thank you. Alexis Rosado, Mr. Mondelli.
He's on his way.
Okay, I was about to say, we're very familiar with Mr. Mondale.
We spoke with him on my office, or I think I spoke with him on Thursday or Friday. He said he'd be here about 10 o'clock.
Hey, I appreciate your office managing those, by the way. I just
Yes,
want to tell you again, I know I do that every calendar call, but I appreciate you managing the attorneys and getting them here around their conflicts and schedules. All right, Sonata is virtual, should be able to unmute.
Your Honor, how are you?
Good morning, how are you today?
Good, thanks. Your Honor, my case is most likely going to be a plea. We were able to come to an agreement with the state, but he does speak Spanish, so I think I don't know where he would end up then.
He would end up coming back tomorrow, Tuesday, at 1:30. If you have your paper, is he here? Segundo Hernandez?
He's with me. He's with me,
Oh, he's
Judge.
with you,
My
perfect.
office.
Okay, then here's what we'll do. If he's gonna report virtually next to you, then what we can do is just have him do exactly what he did this morning, if you're gonna enter a plea, and we'll, have you report virtually tomorrow at 1:30. We'll have a Spanish-speaking interpreter here, it's Miss Ada, Miss Lean, she's wonderful. And, but what we'll do is we'll email you the paperwork. Is this okay, Ms. Shepherd? Does this work for you?
Yes, I spoke with Mr. Sonata's office last week. I just didn't realize he was an interpreter.
Yes.
But I'll get the right sheet and the plea paperwork emailed over to his office.
Okay, I'll email you the Spanish version. I'll email the Spanish version of it if Mr. Shepherd doesn't have it. And that way you can have those signed and email them back. Does that make sense?
Yes, Your Honor, thank you.
Okay, perfect. Well, then, just keep an eye on your email. Have your client have those signed and have them emailed back to us before the plea tomorrow. And then we'll do the plea tomorrow, at the interpreter calendar, which starts at 1:30.
Thank you. See you all tomorrow. Take care.
Thank you.
Bye-bye.
All right, that takes care of that. And you're gonna have that too. All right, Gregory Simich.
Conference.
All right. Scarshog, isn't he in jail?
I think they let him out.
Scarshog?
Didn't
Robert?
anticipate him being here. That should have more time. Yeah, I wasn't real sure how he got out. But, well, that's for a bond forfeiture and a bench warrant.
Yeah.
Both his cases.
And this is a do not reset, so. Yeah, I'm just gonna mark this one as a do not reset.
He is not.
Okay. All right, well, then the warrant, we'll track him down. Ezel Upshaw?
So Judge, Mr. Gardner is the attorney on that. He is one of the lawyers in the Young Thug
Where is
Marathon.
that case?
They're getting ready to strike a jury now. They have enough jurors qualified so that they can begin striking a jury.
10 months later.
They started the first week of
I
January.
know.
It's insane. Insane.
The judge, he, sent a message asking y'all to get on virtual, so I just sent the link to it.
Okay, yeah, I had that email. I was gonna do that. You already sent it?
Yeah, I sent it.
Yeah, that's great. So thank you for that.
I think he had Wednesday morning available, but this will be one we're gonna have to reset because it's
Yes.
a superior court.
Yeah, there's nothing we can do about it.
Legit
Is he
conflict.
the one who came down very briefly on a
No,
Wednesday?
so that was, we got three lawyers who.
Yeah.
Mr. Chada, who
Yes.
comes in here, Surrey, comes through here, is on that, and then I'm trying to remember the third.
I'm just glad that's not us.
Yeah, me too. Yeah, I'll stick with what we did.
Whew. Okay, all right, thanks, everybody, that's good organization, I'll put that as a virtual report. Upshaw, I assume Upshaw will just report when Gardner reports. Okay, Reed's motion to revoke bond is November 9th, 2023, if you want this. That way we just all have the dates.
That's the one that's gonna get her. so.
I don't have a drug in
They'll have her custody.
Actually, I don't have a drug in that fight, so.
You'll get that.
Thank you.
All right.
She's also on felony probation for another ag assault, which I'm assuming is gonna get.
Oh,
revoked.
okay.
This is the gift that keeps on giving.
Yeah, I know.
Okay. I don't know what to say.
Let me know what you need.
I said I don't know. I don't know what I need.
It's a good thing she has such an amazing lawyer. All right, Rodriguez Walker.
Concord.
All right, thank you. I think I said your first name incorrectly. How do you say your first name? Rodriguez. I'm so sorry. Names are important and I messed it up. I'm sorry, Mr.
Anyway.
Well, all right, Demarius Williams, Mr. Singleton? All right. Okay, so that's the calendar for this morning. I know we've got some other folks moving from other calendars over to here, so here's what we're gonna do. Are there any witnesses who received a subpoena? Any witnesses? Okay, no witnesses.
I think they've all been handled.
Okay. Anybody, so anyone here whose name was not called, stand up for me. There's always a couple. Yes,
Your Honor, I have a walk-in Rogelio Flavella Corral. It is signed up for a plea,
wonderful.
and we are ready to go.
It's a bench warrant. Mr. White had been in contact with you and I several times about it. It's an 11.
Oh, right. Okay, happy to do it. Everything's all signed
Everything's
up.
already good.
If you will, if you'll take your client a step out, talk to probation, just make certain that they have everything they need.
Okay.
And Piper, will you have to?
If you go like that over.
Judge, he has to be in the cab, I believe. This
Yeah,
morning
so I'm
also.
gonna take it before I go.
Just go out the double door right there. You go out that door. Probation should be always.
So this is it? Here you go. I was trying to get that to the attorney.
Corn. Let Judge Thacker know about it.
Okay, make it back. Go ahead.
Mr. Todd Riley, the back judge.
You're good. If you're Singleton, I'm not worried about you.
Yeah, we've got him on the list.
Are you Singletons as well?
Oh, my name, but I
Yeah, but he's
was,
running now.
I guess, or somebody else's answer on it.
What's your name?
Taylor Hollis.
You're
Oh,
attorney
yeah,
now.
sure. Yeah, you have an attorney. You're good to go.
Okay.
Your case is in hand. All right, anybody else? Shepherd, floor is yours.
All right, morning, y'all. I'm Patrick Shepard. I'm the solicitor. That means that I'm the prosecutor. I'll be the one doing the conference this morning. This is also Jackie Tony. She's the other solicitor. She'll be meeting with some of y'all as well. What's going to happen is in a few minutes, if you have asked for a conference and you do not have a lawyer, in a few minutes, either Ms. Sherry Middleton, who just stepped out, Ms. Lenise Fletcher over there in the green sweater will call names. When your name is called, you're going to follow one of those two ladies out the double doors over here to my right, your left. Follow them down the hallway. There's a waiting area outside of my office. Have a seat in one of those chairs, and we'll call you back one at a time for your conference. When you're done with your conference, you're going to come back down the same hallway, through the same set of double doors, quietly have a seat here in the courtroom, either enter your plea or get instructions for your trial in a couple of weeks. When you come back in the courtroom, make sure that you do use these double doors, not the single door there. If you come through that door, you're going to disrupt court, make the judge unhappy. It's not a good way to start your week. There's also several of you who are represented by an attorney. If that is you, I cannot speak with you directly because of ethical rules, but we will meet with your attorneys in a few minutes. There's a couple private attorneys here and the public defenders folks. So for the rest of the morning, just follow your attorney's instructions. There's obviously a lot more of y'all than there are of us, but we know what we're doing. We do this just about every day. We move pretty quick. We'll have everybody out here at a decent time today. All right, thank y'all.
All right.
Good morning, my name is Harry Charles. For those I represent in practice, when you call your name, I'm going to be calling you to this door, and you're going to make a video video, and I will be able to discuss your case with you and tell you what to decide. One person has called attorney, Ms. Porter, on the call you, and she will meet with you also and tell you to qualify that, okay? Thank you. Please, if you are too late, go to the restroom and come back, so when I call your name, you'll be here.
All right, so, a couple of announcements, just to make certain we're all on the same page. So I'm gonna take that one plea before we go. I need to speak with Mr. Culberson and Mr. Andrews here. So here's the deal. What I'm gonna say otherwise is, in just a moment, my instructions are gonna be very straightforward. You ready? Hey, step to the restroom and get back to your seats. It's as simple as that. But every single court date, someone, statistically, one of you are gonna volunteer to go to jail. And I don't know why this keeps happening, but I don't know what else to do about it other than to say, statistically, one of you is gonna go to jail because one of you is gonna step to the restroom and never come back. I have no idea where you go. Oil changes, haircuts, I don't know, but I don't care. So the fact that I have to create a solution for this issue, like, tells you that it's a major problem, and the team will tell you, like, this happens every day. So here's the instructions. Step to the restroom, get right back to your seats. They're gonna be calling folks out this door, the public defender's gonna be calling people up here, the bailiff's gonna be calling folks out there, and if you're not here to answer, the first time they call your name, you just go to the bottom of the pile. The second time they call your name, I issue a warrant because that means I can't find you. So again, I'm sorry. I'm sure this is the one group who will not have somebody wander away, but statistically, one of you is going to jail by volunteer. So don't volunteer to go to jail. Just do what we're asking you to do. What I'm gonna do is I'm not gonna get off the bench like I normally do. What I'm gonna do is just put us at ease. If you need to step to the restroom, do that. Otherwise, stay here in the courtroom for them to call your names. Miss Porter can tell me if you want to go do other things.
Oh, I'm good, I'm good.
Okay. All right, tell me how to pronounce your name.
Rogelio?
Rogelio?
Yeah.
Corral?
Yeah.
Okay, names are important, and I always want to get it right, so. All right, please raise your right hand. Do you solemnly swear you will tell the truth, the whole truth, and nothing but the truth, so help you God? All right.
You gotta speak loud so that
If,
they can
yeah, I was
hear
about to say, if
you.
you'll grab that mic, lean in, you can take your hand down, state your full name for me.
Rogelio Favela Corral.
All right. And Mr. Corral, you are here today on a walk-in. It's 23 TK 0773. It is my understanding that you wish to close your case with a plea. Is that correct?
Correct.
And you're here with your attorney, Mr. Jason White?
Correct.
Okay. Did you hear, you were on time for court this morning, correct?
Correct.
Did you hear the rights that I read out to the courtroom this morning, and did you see the PowerPoint that I put up on the wall?
Yeah.
Did you understand those rights?
Yeah.
And are there any questions that I can answer for you about any of those rights?
No.
All right. Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights?
Yeah.
Are these your initials next to each of the lines on page 1?
Yeah.
Page 2? And is this your signature?
Yep.
Did you sign and initial this document after having all the time that you needed to review it?
Yep.
And because you and having an opportunity to ask your attorney any questions you have about it?
Correct.
And because you understood everything that's on it?
Correct.
Are there any questions that I can answer for you about anything on this document?
No.
Now, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yeah.
All right. Are you satisfied with the job your attorney's done on your behalf?
Yeah.
Do you understand that you have the right to a jury trial?
Correct.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Correct.
Okay. Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No.
Okay, if you think of any, do you promise to ask me?
Yeah.
Excellent. All right, so, Ms. White, on count 1, failure to stop at a stop sign, do you stipulate there's a sufficient factual basis for me to accept a no-load plea?
So stipulated.
All right. Do you want to enter a no-load plea, Mr. Corral, to the failure to stop at a stop sign charge?
Yeah.
All right. Moving back to Mr. White, count 2, driving without a valid license. Do you stipulate to the factual basis to the level of a no-load?
So stipulated.
And do you wish to enter a no-load plea to that charge? This valid license charge?
Yeah.
Okay. I'm going to find between the attorney's stipulations as the factual basis and the request for the no-loads, there's enough for me to take the plea. I'm going to find that your no-loads are appropriately being requested, and I'm going to grant them. I reviewed the recommendation, and I'm going to follow it. Give me a second. Let's whack. Let's go for it. Okay, I just had a procedural question I wanted to ask your attorney. Okay, back on record. All right, so the no-lows proper, it's 2 different categories of charges, and so I can do 2 no-lows on this case. It's being knowingly, voluntarily, and intelligently given. I understand English is your second language, is that correct?
Correct.
What is your primary language?
Spanish.
Spanish, okay, and you understand that if you did need a Spanish interpreter, we have an interpreter calendar tomorrow at 1:30
No,
that I could have put you on. You understand that?
Yeah.
And are you comfortable with the idea that we've done this here today in your second language?
Yeah.
And Mr. White, you're comfortable with this?
Yes.
Excellent. Mr. White, do you have anything you wish to add before I sentence?
No, Your Honor, I just asked the court to accept the plea as negotiated.
Okay.
And for the record, I have explained to him potential immigration consequences. Those are being worked on. They're just, immigration's waiting on a court date for for this, but it's in process. So he understands the consequences of this. We'd ask the court to accept the plea.
Okay, perfect. And like I said, that's on the right sheet, and he's initial and not a citizen. So, and I went over that earlier. Okay. Any questions before I sentence? You ready?
Yeah.
All right, here we go. On 23 TK 0773 from February 9th of 2023, count one, failure to stop at a stop sign, the NOLO is granted. It's 11 months probation. $300 is your fine. Count two, valid license, NOLO, 11 months probation, $590 is your fine. I'm going to delay the start of probation by 30 days. If you pay $30, then you will be able to close your case by paying your fine in full plus $30 by participating in our 30 for 30 program. If you are unsuccessful in resolving your case within the next 30 days, then your probation will start. Oh, I'm so sorry, count three is dismissed. I missed count three. Then if your probation starts, then the way it will work is you will need to, I guess you can't get a valid license, can you?
No,
Okay.
not at this time, Your
I'm
Honor.
gonna remove that. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee. And the case will still close upon completion, but you'll need to satisfy those conditions first. So get it in the next 30 days and you'll just have the fine plus $30. Other than that, you'll need to satisfy those conditions. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. You remember reading about habeas on the back of the right sheet there?
Yeah.
All right, and do y'all have any questions for me before we part ways? Anything else?
No, Your Honor.
All right, so you're free to go. I think you're heading to Atlanta from here.
DeKalb, yes, Your Honor.
DeKalb, okay. And who you're going in front of?
Judge Pardon.
Okay, so, well, we were just at the conference last week.
Okay.
And if you'll go with Mr. Hadaway out those double doors, have a safe drive back.
Thank you, Your Honor.
Thank you.
And that'll take, and the bench warrant will be.
Yes, it's on there. I didn't put it, it's on the
Yes.
last line.
Okay,
It says
perfect.
bench warrant.
Perfect. Thank you, Your Honor.
Thank you. Is Rosado yours?
That's mine, Judge.
All right, come on up.
Charles, come up.
Mr. Charles, show me which one of these are yours. Or tell me about it.
About all of them.
Okay, so I was trying to get this.
Speak to blueberry, blueberry, Harvey's.
So I'll do Mr.
And
Mondale's,
Pompey,
and
yes.
then the rest of them. So, all right, Mr. Mondale, if you will, this is Alexis Rosado?
Yes, sir.
All right, men, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, take your hand down, say your full name for me.
Alexis Marie Rosado.
All right, Ms. Rosado, you're here on 22 SR 0886, and I believe you are on time for court today, is that correct?
Yes, Your Honor.
There it is. Okay, did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, Your Honor.
All right, did you understand those rights?
Yes, Your Honor.
Any questions I can answer for you about those rights?
No.
Ms. Rosado, did you, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, Your Honor.
Are these your initials next to each of the lines on page 1,
Yes.
2?
Yes.
Is that your signature?
Yes.
Did you sign and initial this document after having all the time you needed to review it
Yes.
and to ask your attorney any questions you have,
Yes.
and because you understood everything that's on it?
Yes.
Any questions I can answer for you about anything on this document?
No.
All right. All right. Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes.
Are you satisfied with the job Mr. Mondale's done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes.
All right. Do you have any questions for me about anything you can think of before I pivot to your attorney with my next set of questions?
No.
All right, Mr. Mondale, do you stipulate that there is a sufficient factual basis for me to accept this theft by deception plea from May 30th of 2020?
I do.
Do you wish to enter a guilty plea to that theft by deception charge, ma'am?
Yes.
Okay, I'm going to find between Mr. Mondale's stipulation as to the factual basis combined with Ms. Rosado's request to enter a guilty plea that there's enough for me to take her plea. I'm going to find that she is knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I reviewed the recommendation and I will follow it as negotiated. Mr. Mondale, anything you wish to add before I sentence?
Judge, just to confirm that my client is entering plea pursuant to the First Offenders Act, and per discussions with the state, once she completes her initial 20 hours of community service, should she do more community service hours, she would ask that that be credited towards any outstanding fine that she owes. On the case, obviously would not go to the restitution, and that's owed separately. Otherwise, Judge, we ask to accept the plea as negotiated.
Okay, it's not indicated that it's a first offender plea, but that's what you all want to do?
Correct.
Okay, so let me, I'm happy to grant that as she qualifies. Let's just put that on the record. You're wanting to use your first offender on this case?
Yes.
Do you understand that by using your first offender, what that means is that I'm going to withhold the final disposition as far as a finding of guilt while you complete your probation conditions. Is that correct?
Yes.
And that, and Mr. Mondale, although it wasn't said, are you telling me this is recommended by the state?
Yes, this is an express negotiation.
All right, that's fine. And so do you understand, ma'am, that if you, I'll just say when you successfully complete this probation, the way it'll work is it'll be closed without a finding, an adjudication of guilt. Do you understand that?
Yes.
If you're unsuccessful in completing it and I have to revoke your probation, I can choose to take away your first offender at a hearing much like this with no jury trial. Do you understand that?
Yes.
And do you understand that if you ever catch any new charges and you want to use your first offender on them, they will look at your criminal history and they will say, you do not qualify because on December 23rd of 2023, you used your first offender in front of Judge Stacker. Do you understand that?
Yes.
Is that all acceptable to you?
Yes.
All right. All right, and I find that she qualifies for first offender, and I will grant that as part of this plea. All right, then I'm going to find that that everything is proper. I'm going to follow everything as indicated on here. She's knowingly, voluntarily, and intelligently entering her plea. Anything else, Mr. Mondelli?
Nothing further, Judge.
Any questions, Mr. Rosato, before I enter the sentence?
No.
All right, here we go. Alexis Rosato, 22 SR 0886 from May 30th of 2020, count 1, theft by deception. I'm going to grant your first offender, find you guilty, 12 months, $685 is your fine. You may, of course, work off your entire fine amount with community service work, but you have to do the court-ordered 20 hours first. Now, while you're on probation, counts 2, 3, and 4 will be dismissed. While you're on probation, show your valid license to probation. No alcohol, illegal drugs, or hemp products, and you'll be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You are going to pay restitution of $1,893.33 to Home Depot. You'll pay it to probation. It'll get, they will pay it over. The way we do restitution now, and Mr. Mondelli, this is new.
I understand. Pay at the clerk's office and then
Yes.
give a receipt to probation.
Yeah, that's a new system we're trying out, and so I just want to make certain that everybody's aware of it, that you will pay one-time payment of $1893.33 to the clerk's office within 6 months of today, or 180 days. Let's do it that way. Within 180 days, it is your responsibility to show that receipt to probation within 180 days. Now, obviously, if you can't do that, you need to communicate way ahead of time so that we can explore other options, but otherwise I expect you to get it done that way, okay? All right, and if you need a copy of that order establishing that, just let probation know, they'll get you a copy. All right, and then once you get everything done, you may go to non-report. I don't normally grant non-report on first offenders, just to say that out loud. However, with this case and the restitution that I would very much like to be paid, I'm willing to make it, but I just want to make certain everybody hears me say out loud that I am not setting a precedent that I'm willing to accept non-reports on first offenders. I'm just willing to do it in this case alone.
Thank you, Judge.
Don't everybody get excited about that. All right, Mr. Rosato, do you have any questions for me?
No.
You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. All right, you may go with Ms. Yarborough out to meet with probation, get your stuff finalized. Mr. Mondelli, it's always a pleasure to have you here.
Good to see you, Judge, and that's all my business.
Where are you headed to next?
Fulton, got two gentlemen waiting for me.
All right, have a safe drive back.
Thank you.
Okay, Mr. Charles, do you have a preference?
No, Your Honor. However, Miss Nix, Your Honor, she still on the side of the road. I'm asking the court to move the case to tomorrow morning. Before you start the bench warrant, can we put on tomorrow?
Yes.
Nix, yes, it's on page 5 of 9, third from the top.
Oh, okay, I see. All right, so I'm gonna leave the warrant, but what I'm gonna do is I'm gonna make a note that she's gonna come tomorrow morning to court, so that'd be 10:24 report. And we will just simply address that in the morning. So the warrant stays, but I put a note here that says she's gonna report 10:24.
Thank you, sir.
All right, Miss Miller, you there? Let me get her out here.
Yes, Your Honor.
All right, Miss Miller, good morning.
Good morning, Your Honor. Sorry about all the courts this morning.
No,
It's a
that's all
Monday.
right. It's okay. We knew you had conflicts. You communicated well with us. I can see your client is now virtual. What would you like to do with y'all's case?
Your Honor, at this point, we would announce ready. I believe it is something that I can work out. I just need to have a conversation with Mr. Shepherd.
Okay, so then, actually, that's not your client. I'm sorry, that's somebody else. Yeah, that's not yours. Your client was Miss Barkley, and she's just gonna be in contact with you all as to when to come back, so.
Yes, Your Honor.
All right, so what I'm gonna leave it as, I'm just gonna leave it that you pled her not guilty, or we put it down for a jury trial. And that the jury trials will begin, I believe, November 6th at 9 a.m. So I'm just gonna put that, unless I hear different from you, I'll see y'all here on November 6th for trial. If you do work it out ahead of time and you're able to resolve it ahead of time, you're welcome to do it virtually. You're familiar enough with our system and our forms that, we can do that with you So if that would be helpful in getting it in and getting it resolved before trial, so the state doesn't have to have witnesses ready, I'm
Yes,
sure the state would appreciate that, and the court would as well.
Just to let the court know, I do have leave for November 6th, but just that day. I'm available the rest of the week, but that Monday I do have a leave of absence. It's for the Gactel seminar.
Okay, that sounds great. If, so then I'll see you, if not, I'll see you and your client on the 7th.
Okay, that's great. Thank you, Your Honor.
And I'm on the bench all next week. If you do work it out, you want to enter the plea ahead of time.
Okay, we'll see what we can do. Thank you, Your Honor.
Thank you.
Can I be excused?
Yes. You're good to
Thank
go.
you.
All right, Mr. Charles, did you have a preference?
No, Your Honor.
All right, then I'll just do this alphabetically with, looks like Caps is my first one.
Mr. Caps. Mr. Caps, Your Honor. Include 22-0988 and 22-0970 will be dismissed.
Okay. All right, Mr. Caps, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down and state your full name for me.
Alvin Ward Caps III.
All right, and Mr. Caps. Okay, there's the null price, so we'll come back to that one. So there's a null price in 23 SR 0970
Yes, sir.
that I'm setting aside while that's the add-on case. Got it? All right, so, Mr. Caps, you are here on 22 SR 0988 for the purpose of this plea. My memory is that you were on time for court, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney's passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes.
Is this your signature?
Yes, sir.
Ms. Charles, let me get you sign that. Did you sign and initial this document after having all the time you needed to review it
Yes.
and to ask your attorney any questions you have about it?
Yes.
And because you, yeah, that'll work. All right, any questions I can answer for you about anything on this document?
No, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes.
You understand you have the right to a jury trial,
Yes.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes.
All right, let's do this. I'm gonna shut the live feed off, but I'm gonna stay on the record. On, all right, the live feed's open again. I've covered that information. All right, so, Mr. Charles, do you stipulate that there's a sufficient factual basis for me to accept this suspended license from June 17th of 2021?
Yes, sir, I do.
Do you wish to enter a guilty plea to that suspended license charge?
Yes.
All right, back to you, Mr. Charles. Do you stipulate as to the factual basis for the hit and run?
Yes, I do, Your Honor.
do you wish to enter a guilty plea to that charge?
Yes.
And then lastly, Mr. Charles, do you stipulate to the reckless driving factual basis?
Yes, I do, Your Honor.
And Mr. Capps, do you wish to enter a guilty plea to that charge?
Yes.
I'm going to find that between Mr. Charles's stipulations as to the factual basis and Mr. Capps' request to enter the guilty pleas on each of these three charges, that there's enough for me to take these pleas. I'm going to find that Mr. Capps is knowingly, voluntarily, and intelligently waiving his rights in entering these pleas. I've reviewed the recommendation. I'm going to follow it. Anything you wish to add?
Yes, Your Honor. This plea was supposed to be June 7, 2023, but Mr. Capps was released from jail. This is a plea from the jail. That's why you see the 20 days. He already served the 30 days.
Excellent. I'm initialing that line right now.
Right. He already served the 30 days, so that's the reason we have to do it today.
Okay. Well, I've just approved that, so thank you for letting me know that. Anything else?
No, sir.
All right, Mr. Capps, do you have any questions before I sentence?
No, sir.
You ready? Here we go. Alvin Ward Capps III on 22 SR 0988 from June 17th of 2021. Count 1, suspended license. I'm going to find you guilty. It's 12 months probation. $742.50 is your fine. Count 2, hit and run. Guilty. 12 months consecutive. $742.50 is your fine. I'm supposed to at least acknowledge that that the suspended license would qualify for a NOLA. If you qualify, I mean, I'm just required to say that out loud.
He's not qualified.
Okay, that's fine. Just want to make certain that was clear. All right, so hit and run, guilty, 12 months consecutive, $742.50. Count 3, reckless driving, guilty, 12 months concurrent, $792.50 for a total of 24 months probation. 30 days to serve in jail. Counts 4, 5, and 6 are dismissed. You will receive credit for time served in full for the 30 days. Now, while you're on probation for the 24 months, your license is going to be suspended for most of that, but I want you to get your Georgia driver's license back.
He's not able to get it back.
Not able to get it at all, is that correct? Okay. All right, I'm going to initial. Actually, I'm going to leave that. All he's got to do is give a suspension detail report to probation, and they'll pull that off. So that's easy enough. They'll do that. If you give them that, they'll email me the order without a hearing. So we've got a good system for that. Okay, so you're going to need to show a suspension detail report. They'll walk you through that process. No alcohol, illegal drugs, or hemp products. Fourth Amendment waiver searches. $50 per month supervision fee. $25 intake fee, one time. All right, that's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes.
You remember reading about it on the back of the right sheet, right there where I'm pointing?
Yes.
All right, Ms. Capps, you need anything else from me on 22 SR 988?
No, sir.
All right, so that closes out that one. And then on 23 SR 0970, that's the malpractice. I have it here. I'm signing it, and it says that it is dismissed pursuant to plea negotiations. And therefore, this case is now closed. Both your cases are closed. Your felony's still pending. And just out of courtesy, your next court date on that one is?
November 1st, I do believe.
I just remember last time I looked at it, it was soon, and that's all I got. So it's open now. It's thinking. There we go. Yes, November 1st at 9 a.m. You need to be in the Superior Court upstairs, okay? All right, thank you very much. Free to go. All right, I'm sorry, no, you're free to go. You're free to leave to go back to meet with probation. All right. Ms. Dewberry, yours?
Yes, sir.
Okay.
Dewberry.
Okay, you are Octavius Dewberry. Please raise your right hand. You solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand, say your full name for me. All right, Mr. Dewberry, you are here today on two cases, 22 SR 0972 and 22 SR 2197. According to my calendar and my memory, you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. It has both case numbers on it, and it's your rights. Do you recognize this document I'm holding up?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are those your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions that you had about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Mr. Dewberry, have you had all the time that you need to speak with your attorney about all aspects of your cases?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, will you lean into that mic just a little bit? You're a little soft-spoken. Do you understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial on either case, and both cases will be closed?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right. Mr. Charles, do you stipulate, starting with 22 SR 2197, that there's a sufficient factual basis for me to take this reckless driving plea from April 20th of 2022?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to the reckless driving charge, Mr. Dewberry?
Say it again.
Do you want to enter a guilty plea to this reckless
Yes,
driving
sir.
charge?
Yes, sir.
Okay. Moving over to your second case, 22 SR 0972. Mr. Charles, do you stipulate that there's a sufficient factual basis for me to take this battery charge?
Yes, I do, Your Honor.
And Mr. Dewberry, do you wish to enter a guilty plea to this battery charge?
Yes, sir.
Mr. Charles, am I correct that this is not a family violence case?
Yes, it's not, Your Honor. It's just a regular battle.
It was originally charged that way, but it's not pleading that way.
No, it's not.
And that is fine. Okay. And Mr. Dewberry, you want to enter a guilty plea to that battery charge, correct?
Yes, sir.
All right. I'm going to find that across both of his cases, between Mr. Charles's stipulations and Mr. Dewberry's request to enter guilty pleas, that there's enough for me to take these pleas. I'm going to find that Mr. Dewberry is knowingly, voluntarily, and intelligently waiving his rights in entering these pleas. I've reviewed the recommendation across both cases, and I'm going to follow them exactly the way they've been negotiated. Mr. Charles, anything you wish to add before I sentence?
No, Your Honor. Thank you very much.
Mr. Dewberry, are there any questions about anything that I can answer for you before I sentence?
No, sir.
You ready?
Yes, sir.
All right, here we go. Octavius Dewberry, on 22 SR 2197, yes, from April 20th of 2022, count 1, reckless driving, I'm going to find you guilty. It's 12 months probation, $1,232 is your fine. Counts 2 and 3 are dismissed. It's 12 months probation. Obtain a valid license, show it to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee, $25 intake fee. You're to pay $50 in restitution to Spalding County to offset the cost of your attorney, 40 hours of community service work at a rate of no less than 6 hours per week, DUI school within 60 days. You're to have no contact with, looks like Takedria. Is that how you say your first name? How do you say your first name?
I'll tell you.
It says Gotel.
Oh, Takesia.
Takesia Gotel. That's going to carry across both cases. I'm sorry, names are important in Mr. Shepard's handwriting copy. Okay. That's the sentence on 22 SR 2197. Okay, moving on to the next case. On 22 SR 0972 from January 28th of 2022, count 1, battery. I'm going to find you guilty. It's 12 months probation, $735. I'll note for the record again, it was charged as a family violence. It is not pleading as a family violence. It is not a family violence case. Again, show your valid license to probation. Alcohol, illegal drugs, or hemp products should be tested for those. Again, $50 per month supervision fee, an additional $25 intake fee. This case is consecutive to 22 SR 2197 for a total of 24 months probation. Same no contact with Ms. Gotel. Another $50 in restitution to Spalding County to offset the cost of your attorney. That's the sentence of the court. You have 30 days from today if you wish to appeal these decisions. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
And do you remember reading about it on the back of the right sheet right there?
Yes, sir.
Do you need anything from me before we part ways?
No, sir.
All right, Ms. Charles, anything else?
No, sir, thank you.
All right, if you'll step out those double doors with Mr. Hadaway, they'll take you back and meet with probation. Pompey is the next one on my list.
Yes, sir.
Is that what you have? Yes. Pompey?
Ms. Pompey.
If you'll give that to the bailiffs, Mr. Kendall, they'll make sure it's all in the proper form. They don't let me handle it anymore, I keep messing it up.
It was showing.
Okay, raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Jayana Iniki Pompey.
All right, Ms. Pompey, you're here on 22 SR 2265, and according to my calendar, you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Ms. Pompey, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And are these your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right. Can I answer any questions for you that you thought of before I pivot to your attorney with my next set of questions?
No, sir.
All right, Mr. Charles, this is oh, you know what, let me touch that. You're about to enter a guilty plea to a family violence charge. Do you understand from the sheet back here on the second paragraph on page 2, as well as what I discussed earlier, which is by entering a family violence plea, you're going to lose your rights to a firearm for the rest of your days. Do you understand that?
Yes, sir.
And is that acceptable to you?
Yes.
Do you currently have a Georgia weapons carry permit?
No.
Okay. Then, any questions about that before I move on?
No.
All right. Mr. Charles, do you stipulate on 22 SR 2265 to the factual basis for this battery family violence from 10/16 of 2022?
Yes, I do, Your Honor.
And do you wish to enter a guilty plea, ma'am, to this battery family violence charge from that date?
Yes, sir.
All right, I'm going to find with Mr. Charles' stipulation combined with Ms. Pompey's request to enter a guilty plea that there's enough for me to take this plea. I'm going to find that you are knowingly, voluntarily, and intelligently waiving your rights to entering this plea. I'll review the recommendation and I'll follow it as needed. Let's go off record real quick. Do you need to call name? Okay. Mr. Charles, anything you wish to add before I sentence?
Yes, Your Honor. Ms. Pompey was supposed to be in accountability court. She's a dropout from the court. That's why we entered in the plea.
Okay.
Yeah.
All right, that's understandable. Okay, Ms. Pompey, do you have any questions for me?
No, sir.
Okay, you ready for me to sentence?
Yes, sir.
Okay. Ms. Pompey, on 22 SR 0065 from October 16th of 2022, count 1, battery family violence, I'm going to find you guilty. It's 12 months probation, $735 is your fine. I'm going to note by operation of Georgia law that this is no, this is not a high aggravated. Sorry, I marked high negative, then I marked it out. So sorry about that, Mr. Charles. Count 2 is dismissed. Get your Georgia driver's license or show it to probation. No alcohol, illegal drugs, or hemp products. You'll be tested for those. Fourth Amendment waiver, $50 supervision fee, $25 intake fee, $50 in restitution to Spalding County to offset the cost of your attorney, 20 hours of community service work, no violent contact with Demetra Smith, no contact with Ebony Arnold. All right, that's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir, and I have a question.
Sure.
About the no contact, I had speak to my, public defender about it.
That's with,
Well, there's two
they met with
people.
Smith, yeah.
Yes, so I was just trying to see if I still can be around you.
Yes, Smith, yeah, they've separated the two out on the sentence sheet.
Okay,
No
So-
violent contact with Smith.
That's
okay,
right. Your attorney's got it, so,
okay,
yeah, talk to him if you have any questions, but it's exactly what you're indicating to me you're thinking it should be.
okay,
So, we're on the same page.
okay.
All right, then I'm gonna pass you off to Ms. Yarbrough. She's gonna walk you out to meet with probation. Good luck to you, ma'am.
Thank you.
All right, Ramos?
Yes, sir. Mr. Ramos?
Thank you, Your Honor.
You can talk to the bailiff, so I'm not taking questions from the crowd at this time. Ramos? All right, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, say your full name for me.
Frank Ayala Ramos Jr.
Okay, hey, if you're gonna chat, you gotta go outside. You can go talk to Mr. Hadaway in the hallway if you need to. All right, Mr. Ramos, on 22 SR 0929, I show that you were on time for court, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and asking your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
You understand that you have the right, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, and this case will be closed? Is
Yes,
that
sir.
what you want to do?
Yes, sir.
Do you understand that you are about to enter a guilty plea to a family violence charge?
Yes, sir.
And that by doing so, you will lose the rights to carry a firearm for the rest of your days? And ammunition, excuse me.
Yes, sir.
Is that acceptable to you?
Yes, sir.
All right. Do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right. Mr. Charles, do you stipulate that there's a factual basis for the simple battery family violence charge from May 28th of 2020?
Yes, sir, I do.
Do you wish to enter a guilty plea to simple battery family violence?
Yes, sir.
All right, I'm gonna find between Mr. Charles's stipulations and Mr. Ramos's request to enter the guilty plea, that there's enough for me to take the plea. I'm gonna find that Mr. Ramos is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I reviewed the recommendation and I'll follow it. Mr. Charles, anything you wish to add before I sentence?
No, Your Honor, except that this case was a transfer from Superior Court to State Court. So it was charged originally, I don't have to resolve anything.
Okay. That makes sense. Okay, Mr. Ramos, any questions before I sentence?
No, sir.
You ready? All right, here we go. Frank Ramos on 22 SR 0929 from May 28th of 2020. Count 1, simple battery, family violence. I'm going to find you guilty. It's 12 months probation. $685 is your fine. This is a high and aggravated misdemeanor, and that's by operation of law, not by designation of the court. That only matters to you generally if you end up if I end up revoking your probation and you end up going to jail. It controls how time is credited if you end up in the jail. So just don't do that, okay? Counts 2, 3, and 4 are dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested with those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, $50 in restitution to Spalding County to offset the cost of your attorney, 20 hours of community service work. You shall begin a family violence intervention program within 60 days and complete it without interruption. No violent contact with several individuals. So Maria Ramos, Brian Salgado, Jason, which is spelled Jayson, Ramos, and it looks like Maria Ramos may be on here twice. Are there 2 Marias? No. Okay, so I'm just gonna leave that just in the off chance that I've missed something, but it looks like Maria Ramos is on there twice. That's the sense of the court. You have 30 days from today to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier? Yes, sir. Do you remember reading about it on the back of the right sheet, right there where I'm pointing? Yes, sir. All right, do you need anything from me before you and I part ways? No, sir. All right, then if you'll head out those double doors with Mr. Richards. Yeah, thanks. Kathy? Yes, sir. Holmes is in Alpros, as well as Pruitt. All right, Ms. Clark, I've signed your malprocess if you want to get copies.
Okay, may those people be released?
Yes.
Do you want a copy?
Sure.
We got a big copy for us. You want one?
Yeah.
Here we go. 2 copies.
All right, that was Holmes.
All the important people's signatures.
Pruitt.
I just didn't show them as reference, well, I didn't have to.
Yeah, I had a singleton written in for Pruitt.
Oh, okay.
Love for other people to get copies. You're welcome. Now that we're released, if we
Okay. All right, I'm gonna do this virtual, it's a pretrial diversion, so all I'm doing is just giving her a report. All right, Ms. Jones, sent you an unmute request, if you'll approve that, please.
I'm sorry, what did you say?
I just said that I wanted you to do exactly what you just did, so good job.
Okay.
Good job. Okay. So, my understanding is you wish to enter into our pretrial diversion program?
Yes.
All right, so the only thing I need to make certain that you're aware of is that we have good contact information. So if we need you, we will reach out to you at 678-386-1415.
Correct, yes.
And then I think your email address looks like it's, actually, will you tell me your email address? I'm having a little trouble reading it.
Yes, it's Camille New Life at iCloud.
There it is. Okay, now read what it says. It says Camille New Life at iCloud.com. Okay, and did they tell you when to report to probation?
No.
Okay, so you will be receiving, actually, I'm just going to pick a time here. How about, I'm going to put your first report date as,
Judge, before you do that, I just want to let you know that I just started a new job at home,
okay,
and my only off days are Sunday and Monday.
okay. Well, you're going to have to report some because it requires 3 months of supervision. So you're going to need to work that out with the Sentence Enforcement Office. So just need to say that out loud. Actually, I'm going to put you on hold just real quick. I need to get a little bit of information from probation.
Okay, thank you.
Okay, Ms. Jones, you there?
Yes.
Okay, I just needed to speak with the probation, sentence enforcement team member to tell me how they wanted you to check in with them. So here's what we're gonna do. I'm gonna have you call by phone their office, tomorrow between 9 and noon. Their number is 770-467-4206. You can get their number off spaldingcounty.com on the sentence enforcement page. But that's their number. And when you call tomorrow between 9 a.m. and noon, then they will give you your reporting instructions. If you somehow don't catch anybody, make certain to leave a message, they'll call you back. Okay?
Okay, can I just repeat that number? You said it was 770-467-4206?
That is correct. And if you need to confirm it, go to spaldingcounty.com and navigate to the Spalding County Sentence Enforcement page, and you can find all of their information there.
Got it. Okay, thank you.
All right, do you need anything else from me before we part ways?
No, have a good
Okay.
day. Bye-bye.
All right, thank you. All right, I'm gonna give this to y'all. All right, Porter, y'all need anything from me right now? I wasn't giving some other things. Ms. Clark, anything?
Judge, I just turned in a plea and then I'll have one more plea and then
Okay.
I don't know if you got paperwork yet or not.
Let's see what I have here. I've got. Yes. Butler, maybe?
No, that's.
Is that yours? Okay. And then Finley, is that yours?
I have Riley. I think it might be that one that's.
No, we just took one back in the back.
Oh, that's fine.
Oh, okay.
He's doing
Never mind,
probation
never mind.
stuff right now.
All right, well, we'll just keep moving. We'll get to it. All right, Butler's yours. Good. All right, and here, whenever you go out. All right, you're Timothy Butler?
I am.
Can you please raise your right hand for me? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down, say your full name for me.
Timothy Grady Butler.
All right, Mr. Butler, you have two cases on the calendar, 23 SR 0446 and 447. It looks to me like 0446 is going to become a null cross or dismissal after we finish the plea in 447? No.
And one of them was on the calendar for next week.
Oh, okay, so what are we doing with, oh, it's right here, okay. Okay, well then let me start this again. 446 is gonna be a null cross. 447 is gonna be a null cross. And we're pleading to one that's not on the calendar, which is 23 SR 0677. Is that correct?
Yes, sir.
That's, okay, that's what I got it under.
Excuse me.
No, that's perfectly okay. So, all right, so 23 SR 0677. Okay, Mr. Butler, does that sound correct to you?
It does.
Okay, just took me a minute to get that sorted. All right, so we're just talking about 23 SR 0677. Mr. Butler, you were on time for court this morning, is that correct?
I was.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
I did not. But
Oh, that's right, you were with Mr. Kendall.
Right.
That's right, we're just gonna jump forward to this point then.
Right.
I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
I do.
Are these your initials next to each of the lines on page 1,
They are.
page 2,
They are.
and is this your signature?
It is.
Did you sign and initial this document after having all the time that you needed to review it
I did.
and to ask your attorney any questions you may have about it,
I did.
and because you understood everything that's on it?
Yes.
Are there any questions about anything on this document that I can answer for you?
Is this a family violence charge?
No. It was
Okay.
charged as a, well, actually, I don't know what it was charged as, because I don't have that
It's
file.
quite all right.
But it's not entering a plea as a family violence charge. That's a good
Okay.
question. So,
Yes.
That's a perfectly reasonable question, and the answer is no. Any other questions?
No.
All right, do you have any questions specifically on this attorney and defendant plea rights waiver, no matter how small, that I can answer for you?
Not at this time.
Okay, if you think of any, do you promise to ask me?
I will.
Excellent. All right, now, Ms. Butler, have you had all the time that you need to speak with your attorney about all aspects of your case?
I have.
Are you satisfied with the job your attorney's done on your behalf?
I am.
You understand that you have the right to a jury trial,
I do.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes.
All right, do you have anything for me before I pivot to Mr. Kendall with my next set of questions?
No.
Mr. Kendall, on 23 SR 0677 with an incident date of February 21st of 2023, you stipulated to count one, the disorderly conduct charge, that there's a factual basis.
Yes, sir.
Do you wish to enter a guilty plea to this reduced charge of disorderly conduct? I don't know whether it's reduced, sorry, this disorderly conduct charge, Mr. Butler.
Yes.
All right, Mr. Kendall, back to you on count two. Do you stipulate there's a sufficient factual basis for this disorderly conduct charge as well?
Yes, sir.
And do you wish to enter a guilty plea to count two, disorderly conduct?
Yes.
All right, I'm going to find on the two disorderly conduct charges between Mr. Kendall's stipulations and Mr. Butler's request to enter a guilty plea, there's enough for me to take the pleas. I'm going to find that Mr. Butler is knowingly, voluntarily, and intelligently waiving his rights and entering these pleas. I've reviewed the recommendation and I'll follow it. Anything you wish to add?
Well, Your Honor, Mr. Butler did ask me, could he, instead of it being no contact, no violent contact with Miss Butler, and I think, you know, I'm sure you don't remember all of this stuff, but we had been down here before, he had, where you had agreed that he could have no violent contact with her as opposed to just no contact with her.
So his bond conditions were modified by me?
Yes, sir.
To no violent contact?
I think that's what it said. Pretty sure.
Well, that's all right, I'm pulling it up here. It's graded, right?
Yes. But there's also some things going on about that marital residence that you modified that allowed him to go back to his house.
Oh, is this the one where they couldn't, I said you can't live together? Or is that, like I said, I basically do one of those every Thursday, so they do start to run together a little bit.
Yes.
I found the order, it's from June 8th of 2023, I'm opening it now. Yeah, your wife was incarcerated, and I said you could go to the house and stay there as long as she was, yeah, this is coming back to you now.
Yeah.
Yeah, because this was an odd solution to an odd fact pattern. The solicitor's office has said no contact. I'm always very careful to modify those without a recommendation. If you want to, let me just do this. I'm going to say that knowingly, voluntarily, intelligently waiving his rights, and we'll follow the recommendation. Let's take a pause in this. Let you go talk to Mr. Shepherd real quick, see if he has any objection. Other than that, I'm not gonna, I don't feel it's not like you're asking me to modify the fine or something, like, I don't feel comfortable modifying this on the fly without the state having an opportunity to make input. So if you want to explore that, I'm happy to pause this one, do another plea while you all are talking.
Do I? We can proceed.
Okay, then I'm gonna follow the recommendation exactly the way it's been presented. Okay, then, anything else, Mr. Kendall?
No, sir, y'all.
Okay. Is the divorce still, is the divorce meeting upstairs or something?
Yes, we just need to, she signed everything and they agreed to, we just need to get that final decree.
Okay.
We'll do in short order.
And I'm gonna put a little, I am gonna add to here, subject to, any other court order.
Yes.
And that way you got that in there, so that gives you a little bit of wiggle room there. That may fix your issue. Okay, Timothy Butler, 23 SR 0677 from February 21st of 2023, count one, disorderly conduct, guilty, 12 months, 735 is your fine. Count two, disorderly conduct, guilty, 12 months, consecutive, no fine. That's 24 total months of probation. Show your valid license to probation, no alcohol, illegal drugs, or hemp products. Be tested for those, Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, 20 hours of community service work. Currently, it's no contact with Tabitha Butler, but I wrote in here on line 19, subject to any other court order. So if another court order orders differently, You may follow that court order, just do so very carefully and after full communication with your probation officer so that they're not caught off guard. They need to have whatever it is you're gonna follow in their file, so otherwise they're gonna think you're violating the order. I'm just saying, be very careful and communicate well. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Remember me talking about habeas earlier? All right, gotta get a yes on that one. Yes? You gotta do that loud.
Yes,
You were trying. He was vigorously nodding his head up and down, so. Okay, that's it, Mr. Butler. Anything else?
One other thing.
Yes.
Mr. Butler wanted to know, is it possible for him to do community service to pay his fine?
Oh, yes. Yeah, probation will walk you through that. We have a very robust system that will give you options to do. So, and I've just signed the 2 null process. They're going over in the clerk, but your other 2 cases that are on this calendar are also closed.
Thanks, sir.
Here, please.
Thank you, John.
Yeah, good to see you. Mr. Clark, Riley? All right, you are Todd Riley?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, so you can down, state your full name for me.
Todd Matthew Riley.
Mr. Riley, you're here on 22 SR 0779, and according to my calendar, you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
I'm missing you.
He's on the calendar for Wednesday,
Ah,
I
great.
think.
I knew you had someone that you were bringing in on a different day. That's the one. This is that one. Yep, there he is. Page 4 of Wednesday's calendar. Okay. Mr. Riley, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on this document?
Yes, sir.
Are any questions I can answer for you about this document?
No, sir.
Mr. Riley, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right, Mr. Riley, do you have any questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right, Ms. Clark, as to 22 SR 0779, excuse me, from June 4th of 2020, do you stipulate there's factual basis for the reckless driving charge?
Yes.
Do you wish to enter a guilty plea to that charge, sir?
Yes, sir.
And then moving to count 3, failure to maintain lane, do you stipulate the factual basis?
Yes.
And you wish to enter a guilty plea to the failure to maintain lane charge, count 3?
Yes, sir.
All right, I'm going to find with counts 1 and 3, the stipulations from counsel combined with the request to enter guilty pleas from the defendant, that there's enough for me to take the plea. I'm going to find that Mr. Riley is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I reviewed the recommendation, and I'm going to follow it exactly the way it's been negotiated. Ms. Clark, anything you wish to add?
Just want to make sure it says terminate after 12 months if all conditions are completed. And I would also ask that if he completes all the requirements of probation, that it can go to non-report.
Okay, so the first part is a yes, that's part of the recommendation. As far as the other one goes, that's not part of the recommendation. Is that something you spoke about with the state?
No, Your Honor, it's not.
Okay. Let me look at something real quick.
I think this is a first arrest for Mr. Riley.
Yeah, the only other thing he had is take it following too close. I tell you what, I'm not going to grant it up front, but I'm also not going to shut the door. So, so he needs to go and be a rock star, and then come back and ask me.
Okay.
So you need to go and be excellent, and then you need to ask me. And I'm not telling you I'll grant it at that point, but if you want it, That's the bar you got at least touch, correct?
Yes, sir.
All right. we'll go
Thank
with
you, Judge.
All right, Mr. Riley, do you have any questions before I sentence?
No, sir.
Okay. All right, Todd Riley on 22 SR 0779 from July 4th of 2020. Count one, reckless driving. I'm gonna find you guilty. It's 12 months probation, $1,232 is your fine. Count three, failure to maintain lane, guilty, 12 months consecutive, 303 is your fine. That's a total of 24 months of probation. Count two is dismissed. No jail time. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, one-time $25 intake fee, 40 hours of community service work at a rate of no less than 6 hours per week, complete DUI school or show completion. Once 12 months have passed, all conditions have been met and no violations have occurred, your case will terminate. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
And you remember reading about it on the back of the right sheet?
Yes, sir.
Right there.
Yes, sir.
All right, do you need anything else from me, sir, before we part ways?
No, sir.
Where do you live?
Zebulon.
All right, that's it. If you will walk out with Ms. Yarborough. Okay. And Williams is yours as well?
Yes.
This was sitting over there.
Oh, this was that wrong guy. He went,
It was just.
he pled with Jason White, and his final is next week. So this goes to Savannah. It took me a second. Coming up. Okay, you are Demarcus Williams?
Yes, sir.
All right, Mr. Williams, if you will please raise your right hand for me. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, if you'll take your hand out and state your full name for me.
No more race, Montez Williams.
All right, and Mr. Williams, you are here today on 23 SR 0525. And according to my calendar, you are on time, from my memory, you are on time for court, is that correct?
Yes, sir.
Yeah, there it is. And did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Williams, I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
Is this your signature?
Yes, sir.
Okay, I notice an X next to U.S. citizen. You are a U.S. citizen, is that correct?
Yes, sir.
Okay, I just initialed it, we'll keep going. All right, so Mr. Williams, did you have all the time that you need to read this document and understand it?
Yes, sir.
Did you have all the time you needed to ask your attorney any questions you had about it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
All right, if you think of any, do you promise to ask me?
Yes.
Mr. Williams, have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Yes, sir, I am.
Do you understand that you have the right to a jury trial on your case?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
All right. Mr. Williams, Ms. Clark, do you stipulate the factual basis as to count 1, this reckless driving charge?
Yes, Your Honor.
Mr. Williams, do you wish to enter a guilty plea to count 1, this reckless driving charge?
Yes, sir.
All right, back to you, Ms. Clark, on count 2, failure to maintain lane. Do you stipulate the factual basis?
Yes, Your Honor.
And Ms. Williams, do you wish to enter a guilty plea to count 2, failure to maintain lane?
Yes, sir.
All right, I'm gonna find with, Ms. Clark's stipulations and factual basis combined with Mr. Williams requesting a guilty plea, that there's enough for me to take the plea. I'm gonna find that Mr. Williams is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I'll review the recommendation. I'm gonna follow it exactly the way it's been negotiated. Anything you wish to add?
Your Honor, same request for Mr. Williams, and same circumstances, we'd ask to let him go on non-report once he completes all the requirements of probation. And we did negotiate that it would terminate after 12 months if he's with no violations and he's completed it.
Okay.
Mr. Williams has also already done DUI school. He has his paper with him that he's gonna show probation. He did also serve a full 12-month license suspension,
Okay.
but you have your license back now, right? He does have those license back now.
You do, okay. I see this here. All right, well, what I'm gonna do is the same option, I don't know if you call it what I offered the one before, which is go and be a rock star, be excellent, do a great job on probation, get your boxes checked. And I wanna have a quick little hearing where probation sits next to me and tells me what a fantastic job you did. I'm not guaranteeing you that I'll grant it, but I'm telling you that those are the circumstances I need to consider. You understand that? Okay, you gonna go do that for me?
Oh, yeah.
Okay, all right, well then, I think that puts us in a decent position. We can circle back to it. All right, Ms. Williams, any questions before I sentence?
No, sir.
You ready?
Yes.
All right, Damaris Williams, 23 SR 0525, from February 27th of 2022. Count 1, reckless driving, guilty, 12 months. $1,232 is your fine. Count 2, failure to maintain lane, guilty, 12 months consecutive. 303 is your fine. That's a total of 24 months of probation. Get your charged driver's license back, or show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee, $25 one-time intake fee, 40 hours community service work, DUI school within 60 days, or show proof that you've already completed it. Your case will terminate upon 12 months. All sentence conditions have been completed, no violations have occurred. And again, when you get to there, your attorney can request a modification. It's called a modification hearing. Once you have completed all of your terms, and I get to have the hearing where everybody tells me what a great job you've done. All right, you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Anything else before we part ways?
No, sir.
All right, go do a good job, okay? All right.
Thank you,
All right,
Judge.
anything else?
No, Judge, I think that concludes our business if we may be excused.
You may be. Thank you very much.
Thank you.
Finley?
Hi, Your Honor.
Hello.
How are you?
Doing well. All right, so looks like you have 2 cases. One's gonna get dismissed. So 977 is gonna be a dismissal in return for a plea to 978. Okay, ready?
Yes.
All right, could you please raise your right hand for me?
Okay.
Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down and state your full name for me.
My name is Belinda LaQuan Finley.
And Ms. Finley, you're here on 22 SR 0978. Ms. Finley, according to my calendar, you were on time for court, is that correct?
Correct.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, I did, sir.
Did you understand those rights?
Yes, I did, sir.
Any questions that I can answer for you about those rights?
No, sir.
All right, Ms. Finley, you have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it,
Yes, I did.
and because you understood everything that's on it?
Yes.
Are there any questions I can answer for you about anything on this document?
No.
All right. Ms. Finley, you have the right to have an attorney represent you, and you're here representing yourself. Is that correct?
Correct.
Is that what you want to do?
Yes.
Is represent yourself?
Yes.
Okay. Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes.
You are charged with 1 count of criminal trespass, and that you did here in Spalding County commit the offense of criminal trespass. I should open this up for the plea. Let's go for it. This is one of them. All right, back on record. Ms. Finley, that you did here in Spalding County back on May 28th of 2021, unlawfully damage a vehicle, a Nissan Versa, the property of Cecilia Hill, by striking it with an object and causing damage. Did you do that?
Yes.
All right, I'm gonna find with your admission of guilt that there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights to enter this plea. I reviewed the recommendation and I'm gonna follow it exactly the way you've negotiated it.
Okay, but sir, I also need to talk to you about something.
Okay?
Can I go ahead?
Yes, yes, ma'am.
I no longer reside in Spalding County, Griffin, Georgia. Right now, I'm in Henry County, McDonough, Georgia, in a battered women's shelter due to this incident. So I will not have transportation to get back and forth.
Done.
So I had asked her, could I phone in and.
That's a yes.
Okay, thank
I
you.
just, in fact, while you were saying it, I checked phone report and circled it for you. So that's a yes. That's a good request. Anything else?
No.
Okay. Yeah, that's a very reasonable request and I'm happy to grant that. And I'm sorry for the difficult situation your life is in. Our goal is to simply get this through without causing any unnecessary additions to that. We just gotta get this part checked off.
Thank you.
You're very welcome. All right, any other questions before sentence?
No.
You ready? Okay, here we go. Belinda Finley on 22 SR 0978, count 1, criminal trespass. I'm gonna find you guilty. It's 12 months probation, $590 is your fine. You may work your fine off with community service work if you wish. No alcohol, show your valid license to probation, no alcohol, illegal drugs, or hemp products. Can be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. You are to pay restitution in the amount of $225 to the clerk's office within 180 days from today. You will then show that receipt to probation within 180 days. So, so you gotta show the so you pay the restitution to the clerk, and then you show the receipt to probation within 180 days. Do you understand that? All right. 20 hours community service work, no contact with Cecilia Hill. And I've already modified it a little bit and added the phone report after orientation. So you may have to come down once, that's totally up to probation. But if they do require you to come down once, it'll be just that once to get you in the system and then get you transferred back over to phone report, okay?
Okay.
And it's technically, they've asked me to stop calling it phone report because it's technically e-report. It's a new thing they've rolled out that's a lot more robust than just phone report.
Okay.
So it gives you more options. It's better for the defendants.
Okay.
Okay. If you'll step out those double doors, good luck to you.
Thank you.
Oh, and your other case is a malpractice. I'm signing that right now.
Thank you, sir.
Dismiss.
No. That's fine.
All right, now I'm leaving.
This one actually should be in this. That was not really good for her. It just got attached to something else instead. Well, there was another one that came, so it was virtual, and I had to go through it at the same time. And I think it just got. So, yeah, he just got forwarded back in. It needs to go to Savannah, I believe. So, I think he's out meeting with Savannah.
Yeah, I think it's that.
Hair,
Yes, sir.
you can come on up, buddy. James, he missed that standard part of the license.
Oh, close. Got to make sure these. I got Mr. Oliver? Yes, sir. Oh, okay.
if you'll please raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your name down, state your full name for me.
Melvin Hare.
Mr. Hare, you were here today on 22 SR 0875. And it's my understanding you were on time for court, is that correct?
Yes, sir.
Did you hear the rights that read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Hare, you have passed it up to me, this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And do you recognize this, the written version of those rights you read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Because you understood everything that's on it?
Yes, sir.
All right. Are there any questions I can answer for you about anything on this document before I go on to the next set of questions?
No, sir.
You have the right to have an attorney represent you. Do you understand that?
Yes, sir.
And by entering this plea, you're doing so representing yourself. Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes, sir.
Okay. Moving on to the facts of your case, on 22 SR 0875 from July 21st of 2020, it says that you did commit the offense of reckless conduct by intentionally disregarding a substantial and unjustifiable risk by discharging a firearm in the presence of someone during a period of heightened verbal argument. This was a gross deviation of the standard of care in the presence of Lauren Gill, G-U-I-L-L, which a reasonable person would have exercised in the situation, and you did not do that. Did you do that?
Yes, sir.
Okay. I'm going to find that with your admission of guilt as to the reckless conduct, that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation, and I'm going to follow it exactly the way you've negotiated it.
Yes, sir.
Do you have any questions for me about anything?
No, sir.
You ready for me to sentence?
Yes, sir.
All right, here we go. Melvin Hare, 22 SR 0875 from July 21st of 2020. Count 1, reckless conduct. And we'll find you guilty. It's 12 months probation, $735 is your fine. That's a total of 12 months probation. You can work off your fine with community service work if you wish. Count 2 is dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee. $25 one-time intake fee. 20 hours of community service work. No violent contact with Lauren Gill or Keisha Gill. That's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. You remember me talking about habeas earlier?
Yes, sir.
And you remember reading about it on the back of the right sheet?
Yes, sir.
Right there where I'm pointing.
Yes, sir.
Okay, you need anything else?
No, sir.
All right, if you'll step up with Mr. Richards. Walker. If you'll raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Rodriguez Cortez Walker.
And Mr. Walker, you're here on 22 SR 0976. Mr. Walker, according to my calendar, you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Walker, you passed up to me this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are those your initials down the right side of the page? Or excuse me, the left side of the page?
Yes.
And as well as here on the back as well?
Yes, sir.
And is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because you understood everything that's on it?
Yes, sir.
You have the right to have an attorney represent you. Do you understand that?
Yes.
And you're here representing yourself. Is that what you want to do?
Yes, sir.
You understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
All right. Mr. Walker, you're charged with one count of disorderly conduct and that you did here in Spalding County. Okay, it's a reduced reduced charge of count one, and that you did here in Spalding County on April 17th of 2022. Act in a disorderly manner in the presence of Mariette Benjamin Walker, in a manner that threatened the immediate breach of the peace. Did you do that?
Yes, sir.
All right, I'm going to find the reduced charge of disorderly conduct with your admission of guilt. There's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation. I'm going to follow it exactly the way it's been negotiated. Any questions about anything before sentence?
No, sir.
You ready?
Yes.
Okay. Rodriguez Walker on 22 SR 0976 from April 17th of 2022. Reduced charge. Count one, disorderly conduct. I'm going to find you guilty. It's 12 months probation. $735 is your fine. You may work off your fine with community service work. Counts 2 and 3 will be dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver. $50 per month supervision fee. One-time $25 intake fee. 20 hours of community service work at a rate of no less than 6 hours per week. No violent contact with Mariette Walker, Brianna Natron, and Bella Walker. Once 3 months have passed, no violations have occurred, and all conditions have been met, then your case may close. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
Remember reading about it on the back of the right sheet right there. Any questions I can answer for you before you and I part ways?
No, sir.
All right. Well, then thank you very much. If you'll step out those double doors and meet with Mr. Williams. All right, and Tonio answers.
Morning, Your Honor.
Good morning. Did you get your questions answered from the bailiffs earlier, Mr. Andrews?
No, sir. I came, the form that I had last time I was here said that I was coming for today for jury selection.
You did. You sure?
Something similar to that.
Okay, well, let me pull it up and we'll see. I'm looking at it. That's not what it says. Let's put it up on the wall and review it together. How about that?
No, I can take your word for it, but.
No, that's all right. I got it up here.
I
Let's
just
clear
know
this
that
up.
November the 6th was supposed
All
to be
right.
the jury.
Is that your name?
Yes, sir.
Okay. And is that your signature there?
Yes, sir.
These are your initials?
Yes, sir.
Okay. And that's your address and phone number?
Yes, sir.
It says you were supposed to appear for calendar call on October 23rd, 2023 at 9 a.m. And for record purposes, today is October 23rd. The time is now 12:15. It says your trial week for jury and bench trials will be the week of November 6th, 2023 at 9 a.m. So am I correct in saying that this did tell you that your trial week was the week of November 6th?
Right, trial week.
And today's calendar call.
Do what calendar call actually is, Your Honor.
Okay, well, is it fair for me to say that calendar call is not the same as trial week?
No, I was expecting to pick a jury, to go through the deliberation of trying to see who's gonna be on the jury. That's what I thought today was.
Okay, well, you were mistaken. The whole reason I called that other one the trial week was because that's when trials occur. The whole reason this is called calendar call is to show that it's not trials, it's calendar call. It's a totally different thing on a totally different date. So how in God's great green earth did a 2019 case end up on this calendar? I'm just realizing I need to find out the answer to that.
The answer to that is I went back to my home in Ohio, and when I came back down here, the Jackson police gave me a felonious ticket. It gave me a ticket. I just feel like they gave me a ticket, and they saw I had a warrant for a Griffin.
And I lifted that warrant?
No, I don't know about lifting it. You made it so I had to come back to court months ago. I came back. I don't remember the actual date. But I had came back in here about 5 months ago and asked for a jury trial.
Oh, you're the reason I changed the system. This is you.
The
Hey,
system.
you made me change my system.
What's
So,
this?
I was like, this is the case. This is the case that like made me wail and gnash my teeth. You should be in jail. And let me tell you why you should be in jail. I issued a warrant for you in 2019. You got to be free with no witnesses being called to court and me not being able to try your case for 4 years. 4 years. And the fact is that you found a loophole unintentionally in my system where you got to come bebopping in 4 years later and demand a jury trial. And because your case was a citation, the system that I created allowed the jail to immediately release you and set you for a court date. And when I realized that this happened, I was so frustrated with myself that I let you do this to this court. Because I don't think it's fair to the state that you got to have 4 years free bebopping around, and now that they have to go find witnesses from 4 years ago. I would not be happy if it was the opposite of this. I would not let the state do that to you. Let me rephrase that.
Yeah, it was on
I would never let the state of Georgia drag you around for 4 years and then make you find witnesses after 4 years. And so I completely retooled our system, and I said, if anybody else does what Antonio Andrews does, hold them in the jail until I see them. So anybody now under my system whose bench warrant is older than 1 year is automatically converted to hold without bond. So if you're catching that I don't have much patience with you today, that's because I'm very frustrated with you and we don't even know each other because you absolutely found a loophole in my system that I didn't even know existed and that I had to stop and retool my system over. So no, today's not your jury trial. Today's your calendar call. I'm sorry that you got confused about that, but that's your confusion, not mine. I think my forms properly identified what this date was for you and that what you needed to expect. You will reappear here. I'm going to have you sign your jury trial form. What are the charges? Do you have any questions for me?
All right, for one, are you gonna let me self-represent myself because the public defender said he couldn't represent me?
Do you want to represent yourself?
If that's the only choice I have.
No, I'm asking. That's not the question I asked you. Do you want to represent yourself? Yes or no?
I don't, but I will because, like I said, you said this has been 4 years ago, and for those 4 years I've been studying the thing that was the driver's license part. I've been studying what the Constitution has to say about that and what Georgia law says about it and Ohio.
So you spent your 4 years on the run getting ready for this jury trial.
I wasn't on the run. I wasn't running.
You had a bench warrant.
Yeah.
You were running.
I wasn't hiding. If they'd have got me, I came on down here and served my time. But I wasn't.
Nah, you and I are about to get really crossways.
Let's stop at that crossways.
Do not start to tell me that my bench warrant was not something you should have paid attention to. You fled the jurisdiction of this court for 4 years. Yes. For 4 years, my bench warrant was trying to get you to the jail.
Correct.
So don't tell me that you weren't running. You were running because my warrant was chasing you. But luckily for you, you left the state and they weren't going to pick you up out there and send you back to here. And so you got to have 4 years of a free ride, okay? So don't come in here and tell me that you were available to this court because I could not call your case for trial because you were running from my bench warrant. Fair enough?
Fair enough.
Okay. Let's get that part crystal clear. I need to ask you this question again. Are you willing to represent yourself at your trial?
If any of the attorneys that I've asked to represent me will, I'll accept it. But I've been told and sit right outside the door last time I was here that they won't take my case. So.
And you've applied with the public defender's office and you were denied.
That's who denied me. You told me to go out there and speak with him, and face to face right there, he told me that he would not be willing to take my case.
Okay.
Which was
where do you work?
I'm a disabled veteran.
Why in the world have you not secured an attorney in the 4 years that you've been on the run?
In 4 years, I've been to court for driving with no license before. And I paid $3,500 to Ryan and Ryan. They would not speak anything about right to travel or anything pertaining to.
Oh, we're not gonna have to discuss that, are we? Are we really gonna have to talk about the right to travel?
I was hoping.
Goodness. Fine. No wonder they're not representing me. Okay, so you should know I'm not gonna have a lot of patience with that right to travel gobbledygook in this courtroom. I may let you talk about it. I haven't decided yet to the jury, but you should know that I'm not gonna have any patience with it myself. Do you understand that?
Yes, sir. Only thing I'm gonna be stating is Supreme Court cases that deal with driving.
Okay.
And also, the handbook for which driving was made, the Department of Motor Vehicles handbook. I'm gonna be using that also.
Well, we need to circle back to the key question here, which is, what other efforts did you take to get an attorney before this moment?
Out of all the attorneys that I've tried to get to take this case, none will take it.
Who did you talk to?
Ryan, and public defenders.
That's the only two people you've talked to since.
It was about 4 of them, four different people.
You named 2, so is it 2 or is it 4?
It was multiple public defenders and one here, and Ryan.
And who is Ryan? I'm not familiar.
They're the most prestigious attorneys in Dayton, Ohio.
Dayton, Ohio? This is a Georgia case.
Yes, sir.
Okay, so you didn't talk to a Georgia lawyer about a Georgia case, or do they have Georgia lawyers in Dayton, Ohio?
No, I talked to a Georgia lawyer and I called several on the phone. I don't remember which ones I called.
Who practiced at Ryan.
No.
That was my question. Does Ryan have licensed attorneys?
Let me start over.
I'm asking my question, okay? You're gonna answer it, and then you can ask me a question and I'll answer it, but we're not gonna talk over each other.
Yes, sir.
Only one person's gonna run this courtroom, and it isn't gonna be you.
No, that's not me.
No, we are not gonna have any problem with that, because I assure you, I will not let you. My question to you was very direct. You said you spoke to Ryan. It is my job to figure out what efforts you did to get an attorney. I asked you who you spoke with, and you said Ryan. Then you said they're in Dayton, Ohio. And my question for you is very specific. Does Ryan have Georgia attorneys who are licensed in the state of Georgia to practice here?
But they do, but the Ryan was right before I came down here. I came down here in January, and I had spoke with them before I came down here. But when I got down here, I called a couple of attorneys off my phone, and I spoke with your public defender here.
Who are the couple of attorneys that you called?
I'm not sure which one I called, sir.
I'm asking these questions because they're important. Do you want to think about it at all, or you want to just give me that answer?
That's the only answer I have, sir.
Okay. Anything else you want me to know about your history with getting an attorney?
No.
Okay. So then my question for you comes back to the first question I asked you, which is, do you want to represent yourself or not?
If I can have an attorney, I would appreciate it.
Okay.
Because I don't know the ins and outs of courts. Like, you seen that with the form I just filled, the form I had filled out. But I would want one that's going to actually fight for my win versus my, just plea bargain me over to the prosecutor. I wouldn't want that part. Okay. He's actually going to fight for me like I'm going to fight for myself. I would love to have an attorney.
Okay. Well, my decision on the matter then is as follows, which is that I don't know if I put you in oath. Raise your right hand. You solemnly swear or affirm the testimony you're going to give me will be the truth, the whole truth, and nothing but the truth, so help you God?
Affirm.
Has everything you've told me so far been truthful according to this oath?
Yes, sir.
Okay. Antonio Andrews, I find that you were charged in 19 TK 1434 with 3 counts. 1 count of failure to obey a traffic control device, 1 count of driving with an expired license, and 1 count of expired tag. I'm going to note that I have asked you many questions about your efforts to get an attorney between February 14th of 2019 and today? Your answer is that you spoke with an out-of-state law office. You did not provide me with any attorneys of that practice who practiced here. Therefore, that was a null. It didn't matter to me because talking to a law firm that doesn't practice here is not helpful in getting an attorney that would represent you here. You also had one conference with the public defender's office where they decided that you did not qualify for representation. I asked you who you spoke with. When you said you spoke with quote unquote other attorneys, you were unable to provide those attorneys' names, and therefore I'm going to rule that I don't know who they are, and therefore I can't determine that you've made diligent efforts. I'm also going to find that this case was under bench warrant, and as I've already stated, this case, the fact that you got back out and you got to be on the run for this long was caused me to change my complete system. So I am not denying you the right to hire your own attorney. You may hire your own attorney the morning of trial. That's your call. But for me here, the short answer is I'm denying your right to apply with the public defender's office because I'm going to find that you have let's see exactly how many days you had to do it. I want that to be on the record. So do you have any questions for me?
If I can't get an attorney to represent me, can I represent myself?
Yes. So that's the other thing I want to make certain that you are aware of is that you do have the right to represent yourself. And I will expect you to try your case one way or the other, either representing yourself or bringing in an attorney. All right, so I just put it in that your ticket was issued to you on February 14th of 2019. Today is October 23rd of 2023. You have had 1,712 days to secure an attorney, and you have not done so. And I find that another continuance will be highly unlikely to resolve this issue with an attorney. Now, if you go and hire an attorney between today and when your trial is, you're going to be back for November 6th. It's a trial week, so we'll get to it during that week. But if you do hire an attorney, you make certain to be very clear with them that Judge Thacker will not be granting any continuances on this case. Whoever you hire better walk in here Monday morning ready to try this case. Because there's a lot of attorneys who will say, yeah, you can hire me and I'll get a continuance. You make certain to tell them, no, there won't be no continuances. Whatever they come in, they better be ready for trial. All right, so I'm going to grab this verdict form. Looks like you have 3 charges. I'm going to have you sign it, and off we go. Any questions for me?
In the jury selection, if I represent myself, will I be able to pick my own jury or pick?
You will pick the jury in the same way that we pick all juries, in that you will be allowed 3 strikes out of 12. And so of the 12 people, you get 3 strikes, the state gets 3 strikes, and then the 6th left standing will be your jury. I just want to say, when you say you want to pick your own jury, I want to make certain you understood that you do not get to pick your own jury. You will pick it, you will deselect 3 jurors. The state will deselect 3 jurors. Is this a jury trial or a bench trial? You want jury trial. Sorry, you said jury trial. All right, I usually put on here, when someone is representing themselves, that you are waiving the right to an attorney, but since you are not waiving that right, and I have determined that you have waived that right by your actions, I'm removing that language from it, but you will not be able to address that issue with the jury. Do you understand that?
Your Honor, if the public defender said that he couldn't represent me, did he put a reason in there why, other than the right to travel?
I'm relating on, no, I'm just relating what you said. You said you applied and they declined you. I have a funny feeling they didn't decline you just because of that, but frankly, if you, because your reasoning doesn't make any sense to me.
Well, when you told me to go out there and speak with him, I went and spoke with him, and standing outside the door, he said, I can't represent you because he want to work in the state of Georgia again. And if he win this case, apparently he don't think he's gonna work in the state of Georgia. So that's the only reason that I could think of that he would have to say I wasn't eligible because my income is low.
Well, your additional explanation, in all honesty, makes about as much sense to me as the idea of a right to travel. So, if I might just be very direct with you. So your additional explanation makes even less sense than your initial explanation. So,
I understand.
again, you can still hire your own attorney. You know what, I don't have the paperwork I need. You need to go sit in the gallery. I need something else from the state before I can, officially plead you not guilty, so. I need.
Accusation from this solicitor. Yes. Check, give the sheriff, she knows what it is.
Ms. Hicks, this family here.
Raise your right hand. You solemnly swear or affirm the testimony about you in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hands down, state your full name for me.
Ralph Eugene Culberson.
All right, Mr. Culberson, when you announced this morning, you announced that you would like an opportunity to apply with the Public Defender's Office, is that correct?
Yes.
So, your case, you were arrested on your case on June 5th of 2020. Please tell me what steps you took between June 5th of 2020 and today to get an attorney.
I didn't take any.
Okay. And you realize that's 1,235 days that you're telling me you took no action?
Yes.
And you're asking me for a continuance to give you more time to get an attorney?
I needed to speak to one. I made a bad decision the last time I was here. I asked for a conference instead of an attorney.
Okay.
I kind of messed myself up there.
Well, I mean, you've interacted with this court on multiple occasions, and I don't show that you've asked me for an attorney before this. Is that correct?
Right.
Okay. So you've been in the courtroom now with me twice. Or no, you didn't come to your first one.
Just one other time.
Because I issued that bench warrant for you and had you arrested.
Right.
Correct?
Right.
So, all right, this is making sense. So I've got to put on the record then this, which is that up on the wall here. All right, is that your name?
Yes.
And then, is that your signature?
Yes.
And are those your initials?
Yes.
And the last line says, it is my responsibility to hire an attorney or apply for the public defender ASAP. The public defender's office is located at 126 North Hill Street, Griffin, Georgia, 30223. And then it says 678-688-8296. Did I read that correctly?
Yes.
And that's dated March 17th of 2023?
Yes.
Okay. And it gave you a court date to come back and see me of June 7th. Is that correct?
That's correct.
Okay. And did you take any action based off of that advice that you signed?
No, I didn't.
Did you take a copy of that document with you when you left the jail?
No, I didn't.
You did not?
I didn't get one.
They didn't give you a copy of
They
that?
were supposed to have gave me one, but they never gave it to me.
Did you ask for a
I
copy?
asked for it. I did ask for it.
So you asked for it and they refused to give it to you?
They said they didn't have anything to give me. All I left with was my personal belongings.
Okay. I find that very hard to believe since I know for a fact that they give that to every single person as they leave. But I guess we're just gonna have to take your word for it. Okay, well,
The officer told me that he had it for me. He was gonna leave it up at the front desk, so when I got all my stuff, I asked for it and they said they didn't have anything up there.
Okay. Did you come to the court to get a copy?
No, I didn't.
Okay. All right, well, maybe that's true, maybe it's not, but let's move forward here, Mr. Culberson, to the actual June 7th court date. You appeared for that court date, correct?
Yes.
And on that court date, you pled not guilty and asked for a trial, is that correct?
Yes.
Here we go. Okay, so now we're looking at the June 7th date, is that correct? See, 6/7/23?
Yes.
Is that your signature?
Yes.
And on that date, is that your initials there?
Yes.
And you see where that language is identical on here about the public defender's office?
Yes.
On 6/7/23, did you apply in the courtroom with the public defender's office?
Yes, I did.
And what was their answer as to whether or not they were able to represent you?
I don't recall.
Mm-hmm.
It was a family incident, and I told her that my nephew was not going to press charges. So she told me just come on in, sign the paper, I could go.
Well, I see where you said you were going to apply. I'm looking at that on my calendar. Did you ever follow up with them after that court date?
No, all I was told was sign the papers so I could leave.
Okay.
I told my lawyer, I told her that my nephew wasn't pressing charges. She said, well, when you come back, she said, if he's not going to press charges, they'll have to make a phone call, talk to him, and it may get thrown out.
Okay. All right, well, all right, well, Mr. Culberson, the short answer is that you were aware back on June 5th of 2020 that you had charges coming down the track saying you took no action by your own admission. Then you didn't show up for court. I issued a bench warrant for you. You signed a reset notice on March 17th of 2023 out of the jail. And that document, which you initialed, and I'm looking at it, and you agreed, said that you had an obligation to reach out to the public defender's office. I know you're saying you didn't leave there. I'm going to go ahead and tell you, I don't know if that's true or not. It sounds not true to me. But either way, you did understand enough of this document to show up for court on the day it told you to do. So you clearly knew some of the information off of there, at which point you showed up on this day. You asked for an attorney. I sent you over to them. You acknowledged that you had that right. Whatever happened after then, you didn't follow up on it. And so, again, it's just chaos, Mr. Culberson. So I'm going to find that I think that 1,200 and, what did I say it was? 1,235 days have passed. You had a high obligation to move and find out what was going on. You chose not to take action. You chose not to do what you wanted to do, not to do what you should do. And I see no reason why I should delay these proceedings to allow you more time to not do what you're not going to do. So that's it for me. So your request for an attorney is denied. I literally don't know what else to do to make that happen for you. You are not giving up your right to have an attorney overall then. You can certainly hire an attorney, and you can bring an attorney with you if you want. But you need to tell whoever it is that you retain that they need to be ready to come in and try your case, and that I have zero intentions of granting any continuances. Do you understand that?
Yes.
All right. You want a jury trial, a bench trial, or a conference? I don't have a preference.
Conference.
Mr. Shepherd, do you want me to bring him back tomorrow morning, or you want to talk to him this afternoon?
You still have a couple pleas left?
Yes, I do.
I can speak with him. Okay. What's his name?
Culberson. All right, Mr. Culberson, go grab a seat.
Yeah, just have a seat. Let me grab it.
Everything okay if everybody okay if I just keep going? We're so close.
Yes.
All right, anybody feels differently, let me know. All right, I'm gonna do the pleas now while we're waiting. Let's start with Robinson. All right, Mr. Robinson, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
David Allen Robinson.
Mr. Robinson, you're here on 22 SR 1658. Mr. Robinson, according to my calendar, you were on time for court, is that correct?
Yes.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
You passed up to me this self-represented defendant plea rights waiver. You recognize this document that I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1?
They are.
Page 2? And is this your signature?
It is.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because you understood everything that's on it?
Correct.
Mr. Robinson, do you understand from on here as well as from me talking earlier that you have the right to have an attorney represent you? Correct?
Correct.
And you're here representing yourself?
Yes.
And is that what you want to do? Do you want to represent yourself at this plea?
Yes.
Okay. Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there's no trial, this case will be closed, and you'll end up on probation. Is that what you want to do?
Yes.
All right. Do you have any questions for me about anything you can think of so far?
No.
All right. If you think of any, you promise to ask me.
Yes.
All right. Mr. Robinson, you're charged with one count of violation of family violence order, and that here on December 5th of 2020, you had nonviolent contact with Deanna Olliff, O-L-L-I-F-F, and Deborah Torman, which was a direct violation of a protective order. Did you have nonviolent contact with those people? Okay.
Yes.
Then I'm gonna find with your admission of guilt, there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I review the recommendation and I will follow it. Any questions about anything before I sentence?
No.
Okay, are you ready?
Yes.
All right. Mr. Robinson, on 22 SR 1658 from December 5th of 2020, count 1, violation of a family violence order, guilty, 12 months, 735 is your fine. 12 months probation, you can work your fine off with community service work, show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, 20 hours community service work, no contact with Deanna Olliff or Deborah Torman, and you may go to non-report probation once 6 months have passed, no violations have occurred, and all conditions have been met. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about that weird old law habeas
Yes.
earlier? Okay, just remember you got 12 months on those rights.
Okay.
Any questions?
No, sir.
All right, you walk with Mr. Richards out those double doors and go to probation. Simmons? Did you go to Griffin High?
I'm sorry?
Did you go to Griffin High?
No, sir.
Okay.
You know my older stepbrother, John Gordon.
Oh, that's where, I was about to
Yes.
say, I knew your name and was having trouble placing you, so, okay, that's right, so. All right, this all looks good. Ready?
Yes, sir.
All right, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
Gregory Miles Simmons.
All right, Mr. Simmons, you are here today on 23 SR 0592, and according to my calendar, you are on time for court. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
I did.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Simmons, you have passed up to me the self-represented defendant plea rights waiver. Do you recognize this document that I'm holding up?
I do indeed.
And are those your initials on the left side,
They are.
as well as here on page 2?
They are.
And is that your signature?
It is.
Did you sign and initial this document after having all the time that you needed to review it,
I did.
and because you understood everything that's on it?
Yes, sir.
Mr. Simmons, you have the right to have an attorney represent you. Did you understand everything on this document?
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
And you have the right to a jury trial, and by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
Okay. You're charged with one count of theft by taking, and that on count 1, you did on March 9th of 2023 here in Spalding County, take lawn chairs from potting soil from Samuel Baskin with the intention of depriving him of the property. Did you do that?
Sure.
Okay. All right, I'm gonna find with your admission of guilt to count 1, theft by taking, that there's enough for me to take the plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it. Any questions I can answer for you about anything before I sentence?
Yes, sir. I'm getting ready to move out of Griffin, and I was gonna pay off as soon, and then it was supposed to be non-report. What's the soonest that I can pay that off, just so that it's just done?
Your first report date would be my thought. And probation will give you all those numbers in just a minute. And that is what the terms are that are being presented to me. So,
But that is what, you're gonna allow that though, I guess?
yes,
Okay.
yeah, I just said I'm gonna follow the terms.
Okay, all right. I didn't hear that part, sorry.
I think that's okay. All right, that's a good question, and the answer is yes.
Okay, great, thank you.
Anything else?
No, sir.
You ready?
Yes, sir.
All right, Gregory Simmons on 23 SR 0592. Count 1, theft by taking, I'm gonna find you guilty. It's 12 months probation, $735 is your fine. Counts 2, 3, and 4 are dismissed. That's 12 months total probation. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. $50 per month supervision fee. $25 one-time intake fee. No contact with Samuel Baskin or 121 Daniel Street. You may go to non-report once all conditions have been met and no violations have occurred. Probation will walk you through exactly what your checklist is to get your case closed.
If I do pay it all at one time, will they just add like the $50 times 12? Or will it just be a one-time $50?
It's per active report month.
Okay, I got you. So if I pay it off,
So
then
you gotta,
just
you'll
the
at least
one-time
have
50.
one. You'll at least have 1 month.
Right, yes, sir. I got that part, yeah.
Okay, anything else?
Nope, that's it.
All
Appreciate
right,
it.
just step out the little doors there. Okay. So. Let's go for it. All right, Mr. Andrews, come on up. Okay, so I'm marking Matthews as reset. All right, Mr. Andrews,
Yes, sir.
what I have done is, I have up here, it says, no, I printed the wrong one. The document's gonna say, I am the defendant in this matter. I knowingly, freely, and voluntarily waive formal arraignment. I plead not guilty to the charges below and demand a jury trial. Is that a correct statement of what you want me to do with your case?
Yes, sir.
All right, I'm gonna print that correct form then. And what I want you to see is that the state, you came in here on these tickets, but I can't try a jury trial off of tickets. And so the state has converted your tickets into what's called an amended accusation. And he's entitled to a copy of this. So if you'll run a copy for that and give it to him. I'm gonna go grab the verdict form off the front, and then we'll have you sign it, and then we'll have you.
Right. You want a trial on this?
Me? On driver's license?
Do you have a driver's license?
No, sir.
Can you get one?
I haven't had a driver's license since 2017. But, oh, I want to ask you, can you just, okay, you can talk to you later.
Yeah, I am the prosecutor.
Lost my updates. All right, Mr. Andrews, the bailiff is giving you a copy of the amended accusation. That's yours to keep. That is simply a more formal version of the citations you received on the side of the road. Do you understand that?
Okay, I'm trying to take it out right now, sir. I understand what you're saying, but.
I just need you to acknowledge that you have it.
Yeah, they just took the ticket and wrote down what happened.
I'm not asking you to acknowledge that you understand it.
This is trial thing, he gonna go over that with you now.
Do I need to sign and date it?
Well, we're about to review it.
He gonna go over it with you.
All right, so you see where it says I'm the defendant in this matter?
Yes, sir.
Did I get your name correct at the top?
Yes, sir.
And I knowingly, freely, and voluntarily waive formal arraignment. I plead not guilty to the charges below, and I demand a jury trial. Is that a correct statement?
What is formal arraignment? Like,
Formal arraignment is where I formally read that document to you. That's page 2. You have the right to demand that I formally read that document to you on page 2. That's the one you're taking with you when you go.
okay.
It's your call. I don't have a preference on that.
You got the answer to it?
Hold on, right there. Listen to me.
And sign where it says defendant.
Right here.
And I will say again, Mr. Andrews, it is my mistake that you are free. And if you are so much as 1 minute late, I will correct that mistake. And you will not be free any longer.
Never late.
Do not do anything that would make me correct my mistake that you are out. I still do not think it is fair to the state that you've been out walking free for 4 years, and now they've got to go find witnesses from the case 4 years ago. But that's the way this is, and that's my mistake, and I will live with that mistake.
I apologize for that part, for my 4 years, but I wasn't running. I just don't do anything to get in trouble.
I will see you here on November 6th. Again, when we have your trial, I may or may not let you talk about that right to travel gobbledygook. But I will say that you will not be able to address the fact that I've ruled that you've waived the right to have an attorney to the public defender's office. You still have the right to hire an attorney, but whoever you hire needs to come in ready to go.
Okay, on the right to travel, all I'm gonna do is Supreme Court cases.
I will very likely let you address that with the jury, because I will give them the jury instructions as to what Georgia law is, and anything you tell them that conflicts with what I tell them as to the law, they will be bound by the law that I understand.
Not the law of the land.
So, no, I don't know what you're about to say, and I'm just trying to make certain you hear me say that if you say something different to the jury that I do about the law that applies to this case, I win the paper, rock, scissors game, and the jury will have to listen to me.
I need to talk to you before I talk to them.
Yes. That's why we're going to discuss that outside the presence of the jury before that comes up. Okay? I'll see you on November 6th. If you want to go to jail, be about a minute late. If you don't want to go to jail, you better be early.
I'm always on time, never miss court.
Except
one time.
when you did.
Yeah,
Okay.
one time.
Yeah.
In 55 years, one time.
Okay. Thank you.
Have a good day. Good day.
Culberson. Thanks, Kevin. That's his. Those go to Eric. Do you want those back? The tickets?
Is that the originals?
Yeah.
I'll just take
Okay, that's fine.
I'll put them
You can come on up, Mr. Culberson. It's the last one that I have, y'all.
It's
I
the last
appreciate everybody pushing through.
Was he done?
The afternoon.
Let's do it.
He was done. That's the paper. You got the paper? Yeah, it's right here. Yeah, he was done.
I got the last one here. All right, Mr. Culberson, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down, state your full name for me.
Ralph Eugene Culverson.
Mr. Culberson, you're here on 22 SR 8364, and according to my calendar, you are on time for court. Is that correct?
Yes.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes.
Any questions I can answer for you about those rights?
No, sir.
I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because you understood everything that's on it?
Yes.
Are there any questions? Do you recognize this as the written version of those rights I read out earlier?
Yes.
And are there any questions I can answer for you about anything on this document? Mr. Culberson, I ruled earlier at a previous hearing a few minutes ago that you'd waived your right to have the public defender's office represent you at trial. You had a conference at your request, and at which point you have reached an agreement to enter this plea on this case and close it. Is that correct?
Yes.
Is it your wish to represent yourself at this plea? You understand the difference between the two questions?
Yes.
Okay. So, do you wish to represent yourself at this plea?
Yes.
Okay. Mr. Culberson, you understand you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes.
All right. Mr. Culberson, you are charged with uncounted criminal trespass. Your accusation reads that you did here in Spalding County back on June 5th of 2020, unlawfully, knowingly, and without authority, enter upon the premises of Casey Yarborough at Fayetteville Road here in Spalding County after receiving notice from an authorized representative that the entry was forbidden. Did you do that?
Yes.
All right, I'm gonna find with your admission of guilt, there's enough for me to take the plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I reviewed the recommendation and I'll follow it exactly the way it's been negotiated. Do you have any questions for me about anything before I sentence?
No, sir.
You ready?
Yes.
All right, Ralph Culberson, 22 SR 0364, from June 5th of 2020, count 1, criminal trespass. I'm gonna find you guilty. It's 12 months probation, $550 is your fine. Show your valid license to probation, no alcohol, illegal drugs, or hemp products. You'll be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, 20 hours community service work, no contact with Casey Yarborough, nor her address on Fayetteville Road at 4457. You may terminate after 3 months as long as no violations have occurred and all conditions have been met. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember me talking about habeas earlier?
Yes.
Any questions I can answer for you about anything